Lord, may I have your lordship's kind leave in the original side, my lord, to mention an urgent tender matter. My lord, yesterday at 8:40 p.m., my lord, I was technically qualified by in a tender floated by Steel Authority of India Limited. Despite being technically qualified, I have been disqualified. Technically eligible, disqualified. For what? Like a spelling error.
For a spelling error?
Almost like something like that. There was uploaded. These are all e-platform.
Yes.
I was uploading. So my uploadings were all accepted. Now say you have uploaded something incorrectly. Instead of writing A, you've written B.
The
this is
bid has not been opened.
No, my lord, this is on the reverse auction. So the technically qualified bidders, so they will say whoever will lowest, so only the technically qualified bidder. So there is no date mentioned in the tender. So it could be any day. And my lord, considering the fact that, my lord, the next 4 days we are closed, that's the only urgencies.
To move the matter today.
I can well appreciate it.
It won't be possible today. Absolutely no. Come back on the next working day.
So may I come back? My lord, kindly give us leave to file. We'll serve and come back on Wednesday. Deeply obliged, my lord.
May I be permitted for leave
If it could be listed, my lord, we will give you a lot Wednesday. Deeply obliged.
May I be permitted for leave to correct the group of the writ petition classification list, my lord. It has been wrongly filed in group 5, my lord, but the subject matter of the writ petition belongs to the group 9, my lord.
Where is the matter?
Matter has been released by the Honorable Justice Kaushik Chanda on the 3rd of December 2024, my lord.
Yes.
Now it is out of list, my lord.
So let it come. So why are you mentioning it now?
But unless it in group is mentioned, corrected, my lord, it will be not changed by the department.
You mention, we will see. It cannot be passed.
My lord,
at least, my lord, the leave to correct.
No. The file has to come here. Otherwise,
the file will be managed, my
No, you bring the file. The authority will bring the file. You do not have to manage anything.
Under the heading to be mentioned, my lord.
No.
But may I be permitted to mention what matter, my lord? It's an urgent matter. It is a vacating application, my lord. I am suffering, and for that reason, I filed it yesterday, my lord. Fact is this: the persons who have obtained the order of stay before your lordship, suppressing the material facts, they have not been eligible in the tender. They are not participated in the tender. So, my lord, we are suffering a lot because 30 days work is going to be completed, and work order has already been issued. That also was not mentioned. We have started the work also. So, my lord, may it be taken up in the next application day.
The order passed?
Order passed on a week before, my lord.
A week before. And I always ensured that the private parties and everybody are there.
14th June is the date. 14th February is the date.
14th February. Let it appear on 14th. Your matter will also appear along with that matter.
If it is appeared on the next Thursday, I can try my chance, my lord. If your lordship sees that I have no case, if my lord may post it to 14th, my lord, as your lordship will please, I will bow down and
give.
Well, let it be in the application.
6th application. Bring the application.
My lord,
may I have the liberty to mention a matter? My lord, I am mentioning upon notice, I understand my lord is saddled with hearing matters, my lord. But this is a matter which was supposed to
You want inclusion?
Inclusion.
Sorry.
A contempt application.
No inclusions.
I have a lordship leave to mention a matter for inclusion. Your lordship.
No.
Lordship being permitted to mentioning the matter. Lordship, it's a group 9 police in action matter. Lordship is wrongly filed in this group.
Item number
1765 of monthly.
1765. Yes. What were you doing for the entire month? Today is the last day of the month. What were you doing? 1765 released. What is your name?
May I, your lordship's kind leave to mention, my lord, one urgent matter, my lord. This is with regard to, my lord, a construction on my property, my lord. My lord will kindly grant me leave to get the matter heard next week, my lord.
No, sorry. Yes.
My lord, the construction is started by the, my lord, KMDA, my lord. So we are unable to stop. The police is also not hearing, my lord. It's my property, my lord. All of a sudden, they have started the construction over the property, my lord.
Next week, when the upgradations are taken up, please mention. Yes.
Your lordship, there is a application which is pending in MSME court, which has been filed in.
I do not want to know the history of the matter. Where is it?
This is a new motion matter. It's not appear in the list. So
you want inclusion? Please come next week. Call the list, please.
Okay.
Well, this is a challenge, my lord, to the order passed by the Excise Commissioner. My lord, I understand a point of maintainability has been taken because, my lord, according to the state, there is a provision of appeal. But, my lord, my respectful submission will be that the challenge in the writ petition is on two grounds. Number one, violation of natural justice. And number two, if it is a pure question of law, I don't have to go through the hierarchy of appeals. My lord, that is now well settled, my lord. The recent Supreme Court judgment also says that. So, my lord, I'll straight away, my lord, take your lordship to the impugned order.
Only thing, Mr. Siddiqui is having some difficulty today, my lord. If can be taken up next week any day, my lord.
Only not today.
Mr.
If
Siddiqui.
he is a personal difficulty, I'll know.
Call the next one.
My lord, I am for the petition.
Your also last occasion directed me to submit one report on that matter regarding the payment of advocates bill, my lord. My lord, the draft report has been already prepared, but my lord, that was not able to affirm, my lord.
Affirm was for affirming there was probably no order, only a report. My lord,
Report indicating the date of payment.
yes.
Yes.
Affirmation is not
What
necessary.
about the report? You have it with you?
No, my lord, that is not with me, my lord, but I know, my lord, I personally being an advocate, my lord, also tried, my lord. But my lord, that was, my lord, not, I could not be affirmed, my lord. My
No,
lord,
no question of affirmation. Where is the report?
my lord, just now, my lord, not with me, my lord.
Not with you.
Yes, my lord, if it is
Have
not,
you gone through it?
yes, yes.
What is the stand of the authority?
Stand of the authority, my lord, they have, my lord, total submitted 170 numbers of bills. Out of bill, my lord, that near about 90 to 100 bills has been already paid. And my lord, that 15 bills, they have not traced out the 15 bills. And they have also requested me to submit before your lordship, as well as requested to the my learned friend to give the details as well as bills of the 15th bill, my lord.
15 matters? You want duplicate
Yes.
bills? All right. What about the rest?
Rest, my lord, actually, my lord, what happened due to the, my lord, the budget of this year, my lord, that has already been almost exhausted. So for this,
The court is not concerned with the budget. Thing is, the advocate also has his own budget.
definitely, my lord,
Right?
definitely.
So if he had appeared in 170 matters, he should be paid. If you say 100 has been paid and 15 bills duplicate will be supplied, what about the rest?
Rest, my lord, that should be paid, my lord.
Pay it. This is what he wants.
My lord, regarding due to, my lord, that the fund, my lord, of this year, financial year, that has been, my
So
lord,
you admit that the rest payment will
yes,
be made.
definitely. What
payable.
bill they,
Very
what bill they
well.
are
You
not paid,
come
my
up
lord,
with a report.
on
that
the
you-
first day, at the very beginning, I have already submitted
It's
my.
all right. You come up with
Yes,
a report that you will pay, the court will be happy and the advocate
definitely,
will be happy.
definitely.
But then I will keep the matter pending till the payment
And
is
my
being
lord,
made.
particularly the law officer, senior law officer office, that is the respondent number 4. My lord, they have, my lord, taken very practical view, my lord.
Very well.
Actually,
Please
my
come.
lord,
When will you forward the report? With the details, whatever you submitted today.
Details of
yes, my lord.
Whatever you submitted today. When?
Thursday. My lord, the next Friday, or my lord, Wednesday, or Thursday, my lord. Huh?
Wednesday is open.
Friday.
next court
Oh, achha.
We can keep it on the 6th.
Yes.
Let it be for safe side, ma'am.
7th. You forward it by 5th. I'll keep the matter on the 7th. On the prayer of the learned advocate representing the respondents. Time to file the report is extended till 6th of February. List on 7th.
Yeah.
My lord, I appear for the petitioner in this matter. My lord, briefly I will indicate, my lord, I wish not to press the matter, but your lordship would kindly hear me for a moment.
Why?
My lord,
If you do not
my
want
lord,
to press, it's up
I do
to
not,
you.
my lord, I do not want to press with liberty, my lord, to, my lord, approach the DRT, my lord, in the pending essay number such and such, my lord. If your lordship
My lord,
can
I appear for
that
the
be-
State Bank of India. Your lordship.
Yes,
can do.
please.
IDBI,
my
my
lord.
lord. I appear for the IDBI. My lord, which
State
is, my
Bank
lord,
or
the respondent
IDBI?
here.
I'm sorry, my lord. IDBI. I'm so sorry. IDBI.
I have the written instructions with me, my lord, if your lordship kindly
Yes.
considers. I'm for the auction purchaser, my lord. I had deposited a certain sum.
Whatever, please come.
Itanian kindly.
Learned advocate representing the petitioners submits that his clients intend to approach the Debts Recovery Tribunal for relief. Stop. Prayer has been made to permit the petitioners to withdraw the instant writ petition.
My lord, with liberty to, my lord, appear in essay number 37 of 2023. I have been added as a party therein, my lord, by the borrower.
In view of the submissions made herein above, the instant writ petition stands dismissed as withdrawn.
Please.
Kagoscha nininna.
Please, ninna, eta din, my lord.
Stop. It will be open for the petitioners to take appropriate steps before the Debts Recovery Tribunal.
Tribunal 1, my lord, in essay number 37 of 2023.
Essay number 37 of 2023.
My lord, I'm
Disposed.
deeply obliged.
Grateful. Deeply obliged.
Oh, my lord, I appear on behalf of the petitioner. May it please your lordship and may file my affidavit of service, my lord. Lord, this is a matter pertains to where the petitioner has been selected as a successful bidder by the Eastern Railway in connection with a tender process in relation with converting the unauthorized hawkers in the railways into a skill development program. That program belongs to the railway in furtherance to a proposal given by the railway board under the.
Please repeat.
My lord, this is
For your project
for converting the unauthorized hawkers
yes
within the railway
yes
to be into through a skill development program,
Okay.
so that the project is under the non-fair revenue head of the railways. Now, by virtue of which the petition is supposed to pay a certain license fee for the particular tenure of the agreement, and from that the railway is supposed to gain. So initially, I have completed all my formalities. The agreement was pending for execution. At that point in time, since nothing has come up, I approached before this honorable court seeking a direction upon them to consider my representation so far as execution of the agreement is concerned. At that point in time, this honorable court was pleased to direct and dispose of the petition, saying that you consider the representation in the meantime, and also observed a certain view that this project is of a benevolent nature, and that the honorable court doesn't find a reason as to why this kind of a project of a benevolent nature should not be give a credence out of that. Now, my lord, thereafter order impugned was passed, which is under challenge. This is by the railway. Now, what they have come up with some unfounded reasons, not even taken a pragmatic approach so far as denying of the claim towards non-execution of the agreement. Now they are saying that we are cancelling the tender process, and whatever I have paid so far, the amount will be refunded. Now that order impugned is under challenge on twofold grounds, my lord. One is the reasons bestowed by the railways at the time of adjudication of my representation. That is one. My lord, the secondly, the view of this honorable court, which was taken on the earlier round of litigation, that has not even been considered. May I take your lordship to the order impugned, order passed by this honorable court in the earlier round of litigation. Well, it starts from page 127.
But is there any scope for passing any interim order?
Well, no
scope.
No
So let them file their opposition. Please come.
The only thing, if it's in a time-bound manner, my lord.
The petitioner is aggrieved by the reasoned order dated 21st of August 2024, passed by the General Manager, Eastern Railway. Refusing to proceed with the contract. Paragraph. There is no scope for passing any interim order in this matter at this stage. Paragraph. The respondents are directed to file their affidavit in opposition within a period of
4 weeks.
4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing.
Good. Good.
Service taken on record.
Madam, my lord, pursuant to the direction of this honorable court, my lord, district engineer has submitted a report wherein the district engineer stated that there is feasible for my lord, installation of a new electric meter in the name of the petition. My lord, the factual aspect involved in this matter is, my lord, the petitioner, my lord, has taken over the business of the, my lord, Monmohan Hosheri, the petitioner before lordship, my lord, by virtue of an agreement and upon payment of, my lord, valuable consideration in favor of the, my lord, erstwhile proprietor of the, my lord, the proprietorship farm. Now, my lord, for the purpose of, my lord, carrying on business, my lord, the petitioner has applied for a new electric connection for the electricity of CSC, my lord. CSC, my lord, informed the petitioner that, my lord, it is not possible for them to, my lord, hold any inspection of the premises since objection has been raised by the, my lord, private respondent. So, compelling the petitioner to approach this honorable court. Now, my lord, kindly have a look, my lord. First, my lord, the report, my lord, submitted by the, my lord, district engineer. My lord, I am skipping over the other portions. My lord, page 2 of that, my lord, report, my lord, paragraph 3. May I read for you, Lordship, my lord? During such inspection, upon being asked by the undersigned to produce cogent documents such as trade license, rental agreement, or any other relevant document to establish this claim, or being a bona fide occupation and the ownership of the identified portion, and also corroborating his claim of future commercial plans, however, he was unable to produce any relevant documents. The identified portion was without any electrical fittings like wiring, switchboard, light fan, etc. However, upon inspecting the existing service position at the premises in question, we found that it is technically feasible to provide a new meter supply in favor of the petitioner at the existing service position. My lord, the whole objection of the, my lord, private respondent is that, my lord, I am in unauthorized occupation. My lord, the proprietor of the present farm, my lord, has taken over the business. And now, my lord, the respondents also filed the eviction suit against the, my lord, the original tenants, my lord, wherein I am also a party to the, my lord, proceeding, and that is pending before this honorable court. My lord, kindly have a look to the cost title of the, my lord, that
You are not a tenant.
no, I am subtenant, my lord.
Subtenant.
Subtenant.
Where is the tenant?
The tenant has given me the position to the, my lord, proprietorship farm. Now, my lord, kindly have a look, my lord, to the affidavit in
There is an eviction suit pending between the parties.
this honorable court.
Whatever, wherever it is. Why don't you obtain an order in that proceeding? Why in the fresh proceeding you have sought for an order?
But beforehand, I have filed this petition. Thereafter, my lord,
Well, I'll give you leave. You approach before that forum to obtain necessary orders. Because your possession, your status, everything is disputed.
No, my lord, kindly have a look to my reply, my lord. Kindly have a one.
Your reply will not do. The
no,
authorities...
their cost title, they have admitted, my lord, kindly have a look to page 18. My lord, kindly have a look.
Yes.
Kindly have a look.
Yes.
They have admitted my possession. That is their suit, my lord. That is in the plain, they have, my lord, made me a party. And while they have stated Ratan Sahu carrying on business under the name and style of Monmohan Hosheri as sole proprietor thereof, residing at 73 New Goswami Lane, Kolkata 7,05,000 within the jurisdiction of the apostate. They have admitted, my lord, that I am in possession. And my lord, section 43, my lord, provides, my lord, that I am entitled to, my lord, get a new electric connection. Whether my tenancy right is, my lord, lawful, unlawful,
that is a different thing.
The subject matter of the eviction suit.
Yes.
I am a party to that proceeding.
Right. But your possession is...
They have admitted, logically have a look, they have admitted in their plain. And my lord, the CSC also at the time of inspection, my lord, found that I am in possession.
No, it says, see, paragraph number 3. You could not produce any cogent document, trade license, rental agreement, or nothing to establish your claim. And unable to, there was no electrical fittings, nothing of the sort. The room is in a dilapidated condition without a door. How do you enter the room without a door?
But I am taking steps. That's why, my lord, I have applied for new electric connection. My lord, I have annexed all the documents with this petition. My lord, the district engineer stated that I am unable to show any documents. Now, my lord, with the writ petition, my lord, I have annexed all the documents. My lord, that is the trade license, that is the, my lord, rent control challan and everything. my lord, in their opposition, only one, my lord, document is very relevant, for which, my lord, the private respondents are, my lord, opposing that one letter I had written, my lord, to the landlord. That is that page, my lord. Page 57, my lord. Well, that is, my lord, misinterpreted.
Read petition, Dekhi. Read.
My lord, reply, my lord. Reply of my reply, my lord, 57 page.
57.
On the basis of this letter, my lord, the private respondent is, my lord, raising objection. Lordship, can you have a look to the letter, my lord? This is to inform you that I, Ratan Shah, received your letter dated 19th October 2022 in connection to land measuring about 1 cut 40 square feet being demarcated eastern portion of premises number 12 Bikepal Avenue, old number such and such. I state and concede that I do not know your client and do not reside in the above mentioned address, nor I have resided there, and also I know none on the senders of the letter. I also said that the letter has been sent to me does not make a concrete sense. Also, the paragraphing is incorrect and it seems that the letter is incomplete. I request you to state why this letter has been sent to me, as I do not find the remotest affiliation with the senders and the premises number mentioned above. Now, what I have stated that I do not reside there. But I am carrying on business because the erstwhile proprietor was carrying on business as in the name of the petitioner. But that has been, my lord, assigned to me by virtue of an agreement. And I have paid, my lord, substantial amount to the erstwhile, my lord, the proprietor, for, my lord, taking over charge of proprietorship business. So, my lord, section 43 provides, my lord, that I am, my lord, entitled to, my lord, the electric connection. Well, whether I am in unlawful possession or not, well, that is the subject matter of the suit. Let it be decided, my lord, in accordance with law. But that is not
Private respondent, is anybody appearing? Yes.
My lord, my learned friends, clients will not admit by their own admission that they are not in settled possession.
Is it the same letter that he showed just now?
Yes, he says that he is not in possession. And not only that, my lord, initially, my lord, when I pointed out this letter, my lord, the court had asked him to file an affidavit disclosing what right he had. Now, my lord, against that order, my lord, we preferred an appeal, and the Court of Appeal, my lord, has passed this order without interfering with that order. আচ্ছা আমার কাছে আচ্ছা আমার কাছে হবে Will it kindly come to page 2, last paragraph.
জাস্ট আগের কথাটা যে হোয়াট ইজ দি প্রপার্টি যেখানে ও ক্লেম করছে আমরা অপশনে দিয়েছি আর ও রিপ্লাই এ কোনো নতুন ডকুমেন্ট দেয়নি, এই এগ্রিমেন্ট যেটা বললো সেটাও দেয়নি।
That's number one. Number two is, Millard, this is corroborated by the statement made by the inspection, Millard, that he does not have any document.
Para 3 of the trip. That was the definitive reply. এটাও রিপ্লাই
ওই যেখানে বলেছে যে হ্যাঁ
এই দুটো দেখাতে চাই, তুমি আগে ছবিটা দেখিয়ে নাও।
Number 3.
What is your submission with regard to his possession?
Will it kindly come to my opposition, which is page 11, R2. I'm just trying to corroborate what the CEC has said is correct. Will your lordship finds this open space? This is the place where he says he's carrying business from. And there is no denial of this.
Open space. So the CEC report says it's a room without any entrance.
What he's trying to do is, Millard, your lordship will find this space, this open space, which he is claiming he wants an electricity connection over here. That's the reason, Millard, why, Millard, when the CEC went, Millard, they found that so far as that open space on any portion of the building, it does not have any document to show that he is either in settled possession, forget rightful possession, forget illegal possession, that he is in possession. Number 2. Number 3 is when I confront him, when I write to him, he says that I never resided in that portion. Now he's trying to explain it, Millard, by saying that I said I never resided in that portion, that I'm not carrying on any business. So in other words, what my learned friend is trying to say that I am in some form of possession over there, which is falsified by the report, and there is no objection to the report.
Right or reply.
He tried to explain the admission by saying that it's not residence, it's business. But that is also not coming forward from the report. So before a writ court, Millard, the best possible evidence from an independent party is there that he is not in possession, nor he has any right. And more importantly, Millard, in that letter where he claims that he has made an admit, there was no admission, he does not even say that I'm carrying on business. He says I have no connection with this premises. I'm surprised why this letter has been addressed to me. Am I not? Just a minute, please. So, Millard, the issue is, if this man, because now, Millard, the law has
Who
changed.
is for CESC?
Lordship, I'm agree.
What is your submission?
Lordship, we have done the inspection, and as we have mentioned in the report, that he couldn't produce any relevant documents, but he's in possession. So
He's in possession. Where from are you getting that line?
From that document. My lord, from their document, page 60 of my reply. Their learned advocate has, my lord, admitted that I am in possession. Kindly have a look, my lord, page 60 of my reply. This is the letter of the, my lord, learned advocate issued to, my lord, in favor of my the petitioner. Of my reply, my lord, dated affirmed on, my lord, 13th day of October 2023. Page 60. Lordship, can you have a look? They have admitted that I am in possession. Paragraph, second paragraph. In breach of covenants and conditions of the lease to be observed and performed by the lessee, you have unauthorizedly and without my client's consent assigned or not sublet the demised premises to one Ratan Sahu of 73 Nimu Goswami Lane, who claims to be the proprietor of Monmonosiary, as appearing from the report dated 7/8 of the SI of Jorabagan PS filed in MP case in the court of the Learned Metropolitan Magistrate, Third Court, Calcutta, and you have also failed and neglected to pay the monthly lease rent for the last several years. In the circumstances, the said lease stand determined by forfeiture under Section 111G of the Transfer Property Act. The said Ratan Sahu has broken the wall on western side of the leasehold property and has gained unauthorized and illegal access. They have stated.
Please come.
And Millard, in reply to this is that letter at page 57 where he says that I do not decide, nor do I.
Yes, I do not decide.
The petitioner claims to be in possession of certain portion of the structure at 12 BK Paul Avenue, Kolkata 700005. Step. Prayer has been made to supply electricity at the portion which the petitioner claims to be in possession. Stop paragraph. In compliance of the direction passed by the court, comma, the CESC personnel conducted a spot inspection. Stop. During inspection, the authority found a 3-storied building wherein in the ground floor, the petitioner showed a vacant, dilapidated room of approximately 400 square feet with no door at its entrance. Stop. The petitioner claimed to be the proposed hosiery store for which application was made for obtaining commercial loop meter. Stop. During inspection, the petitioner failed to produce the trade license, comma, rent agreement, or any other document to establish his claim to be in bona fide possession, bona fide occupation. Stop. The identified portion was without any electrical fittings like wirings, comma, switchboard, comma, light, comma, fan, etc. Stop. Paragraph. Learned advocate for the petitioner submits that the petitioner is a subtenant of the said premises. Stop. An eviction suit is an eviction suit between the landlord and the tenant and also against the proprietor of the petitioner is pending consideration. Stop. Paragraph. Prayer has been made now in support of the submission that the petitioner is in possession of the a portion of the property. Reliance has been placed on the communication dated 19th of October 2022 Who is this AP Agarwal? Your counsel. In 22, written by the learned advocate of the private respondent. And who are these? Alok Goenka, Anil, Vinay Goenka, they are all?
They are the original.
Original?
They are the original lessees.
Lessees.
Legal heirs of original lessees.
Legal heirs of the original lessees. And Millard, the reply to this 19th October letter is at
to the original lessees that they had sublet the subject premises in favor of the proprietor of the petitioner, and the proprietor of the petitioner broke open the wall of the leasehold property and gained unauthorized and illegal access to one room, and is also trying to make unauthorized construction on the property. Stop. Next. The petitioner, the proprietor of the petitioner, has by a communication dated 1st of November 2022 addressed to the learned advocate for the private respondents that he does not reside at the subject premises. Stop. Paragraph. Prayer has been made to direct CESC Limited to provide electricity connection to the petitioner as according to the letter of the learned advocate for the private respondent. The proprietor of the petitioner has gained access to the subject property. Paragraph. Learned counsel representing the private respondents. How many are there? Acha, action, private respondent.
Just
Specifically mentions that the petitioner, the proprietor of the petitioner is not in possession of the subject premises, but is trying to take possession of the same. Step. An eviction suit is pending between the parties. Step. Next. The report of the CAC mentions that it is feasible that electric connection can be provided. Paragraph. The court
at the cost of
in
interference.
please wait.
Sorry.
The court in the order dated 25th of September 2023 clearly recorded that it is well settled that a person in possession of a property is entitled to enjoy electricity under Section 43 of the Electricity Act, 2003. Stop. From the submission made on behalf of the parties, this court is not satisfied that the petitioner is in possession of the subject property. Stop. Paragraph. The fact of possession of the property is seriously disputed by the private respondent. Stop. It is a factual issue which cannot be adjudicated by the writ court. Stop. The parties have already approached the civil forum for remedy. Stop. It will be open for the parties to make appropriate prayer before the civil court for relief. The prayer of the petitioner for grant of electricity connection in the instant writ petition cannot be allowed. The writ petition stands dismissed.
But I apologize for interfering when the court was dictated.
Seven, my lord, I appear on behalf of the petitioner.
My lord, your lordship directed me to produce the copy of the deed because the case of lord non-completion of registration.
What does it say?
The deed lord is otherwise complete in all respects, but so far as
Signature is
biometric is concerned, my lord, biometric signatures are there because the execution is done, my lord. It can be done outside the registered premises also.
Biometric is not there.
That is the report. Otherwise, deed is complete, but deed number is not there. So this is a copy, my lord.
But then tell me, how did the registrar sign the document without the biometric?
No, he has not. After presentation, there are three stages. One is execution, next is presentation, third is registration. Now, my lord, execution can be outside. Presentation has to be before the registrar.
Yes.
It can be within a period of 4 months from the execution.
Right.
So the person has to come within 4 months and do the biometric. That was not completed. Biometric was not completed. So presentation was not complete. So we could not register.
What happens? Because if I can correctly remember, he said that the person is not available or traceable or he has died or
First
something.
of all, without seeing the executor or the assigner and the assignee, the registrar will not even put his signature. Kindly, my lord, I will show from the act itself that both the parties has to be present.
Let
that
me
too
see
physically.
once. Dekhi,
And I have called my client, my lord, he is here also.
No, he's staying here will not help.
Kindly take this copy.
And
That is the stitch copy. I'm sorry.
signature of the registrar is there. Yes, the additional
Everything
registrar is signed.
Everything is there.
How could it be signed?
Document is presented.
Yes.
So we have to, yes. Now presentation, they have to complete that part under section 23. Biometric by not personally appearing.
Listen, without the biometric, it cannot be done. What is to be done now? The person is not traceable.
Not traceable, my lord.
What is to be done?
My lord, biometric, my lord, my lord, if the registrar has put the signature,
Listen,
the act says that it is complete.
Cannot be done. The biometric is not there. The biometric is not there. The authorities have not lost it. This is not your case that they have deliberately lost
my
it.
case. That is what I have pleaded in my writ petition also.
Deliberately lost it.
Yes. And one more thing is that, my lord, they have not, yes, I'll give a reply. I'll give a reply. Only one thing is that I have given a representation to them at least 5 months back. They didn't choose to reply.
Very
Number
well.
one. Number two is that, my lord, section 32 says that only when the presentant, that is both the parties are present physically, then only the registrar endorses it. The
Well,
rule
very
says,
well. They physically appeared, signed,
Now,
but the biometric not done.
greatest of respect, one person will go to the registry office, put his signature, registrar will confirm, and that person will do everything, pay the money to the state and come back without doing the biometric. Can it be a feasible ground? With greatest of respect, my lord.
What is the way out?
What is disputed? He is saying that he has gone there but not done the biometric. That is disputed. We have said that he has not physically appeared before the registrar. That is our stand on oath, which they have not yet disputed.
I will
dispute, then we shall try to procure the copy of the video recording if it is still available of that day, whether he was physically present. But
November 2023, I doubt.
Then he would have objected, saying that my biometric was not taken. Had it been a case that his biometric was not taken,
it was done. That's why I didn't object.
Has he mentioned it anywhere in the writ petition that the biometric was done? देखिए एक बार.
But first I'll show the representation once, which is at page 70. My lord.
No, what have you pleaded in your
Yes.
writ?
otherwise stamp duty has been paid. Other parts are not complete. I have to not confess not. Other formalities are complete.
Now, if the person is not available, what is to be done now?
But it kindly takes up from para 8 onwards.
4 months, it can be extended another 4 months.
The person is not available. What is to be done?
No, then presentation is not complete, my lord. Then we cannot register it formally. And if it is not registered, my lord, the transfer is not complete. If the registration is not complete formally, as per the Transfer Property Act, transfer is not complete. That person has to come. If they have made a representation, I have had a talk with the registrar. He can extend it. Maybe have a token, fine or penalty, and he can.
He doesn't want an extension because the person is not available.
In that case, our manual doesn't provide. If in the absence of that person, it can be done. That is not provided in the rules, at least.
Well, Rule 21 says that what is the procedure to be
Sir,
followed.
I cannot help you.
But only, it kindly considers Rule 21 once. Thereafter, your lordship passes the order. Kindly,
The court cannot force the authority.
With greatest of respect, the registration is complete. If your lordship looks into Rule 21, sub-rule H, it completely says that when both the persons are present, in the presence of them, the registrar has to see the identity cards.
If you say
yes,
that despite being there and despite the biometrics being done, the authority is deliberately not registering the document, then it is a different case made out.
That is my case.
Where have you said that the biometrics were taken and everything? In that case, you have to lodge a complaint before the police against the registrar that he is deliberately.
But I have only one. That's a mistake I have not done. I have not done a police complaint, but I have written at page 70. Kindly see. That is my representation. Paragraph 4 at page 71. I have specifically stated that as per the usual practice and procedure, the registrar has scrutinized the entire document and allowed the registration process to complete. The registration was completed.
No, where have you mentioned about the biometric?
Now, and both the assigner being Topon Guin and assignee being my client undergo the entire procedure. The entire procedure includes the biometrics, my lord. And now the next paragraph, after the entire procedure was completed as per West Bengal form number such and such, being IGR was issued giving serial number of the deed being such and such. Upon receipt of the said notice, my client left the registry office, but the deed was never given to my client. Consequential thereto, my clients obtained a receipt from the
Is the
website.
transferor a party over here? No.
Well, a transferor is not a party. If your lordship directs me, I'll make him a party and I'll try to serve upon him if he's at all available.
Make him a party. Let us see if anything can be done. Ashunta. Photocopy of the deed of assignment. Dated 11th November 2023. Has been produced by the learned counsel representing the state respondents. The specific stand of the state is that that one of the parties to the deed was not present at the time of presentation of the deed, for which the biometric of the said party could not be taken on the day the deed was presented for registration. Stop. Next. From the deed, it appears that the assigner therein is not a party in the instant writ petition. Stop. The petitioner is directed to implead the assigner as party respondent in the instant writ petition and serve copy of the writ petition upon the said respondent. He is somewhere in Durgapur.
Yes.
Burdwan. What is this assignment about?
Well, it's regarding a flat in Salt Lake.
Leasehold right.
Leasehold right. No, cooperative society flat. Cooperative society flat. It was transferred. Kindly see, I have annexed the agreement for assignment, initial agreement, which is at page 24.
Achha. Relist the matter on 24th of February 2025.
But only one thing, may I file my reply in the meantime to the opposition filed by the statement.
As you choose, I do not know.
Is to be given in that.
After all these things, how much the writ court can help you. It will be open for the petitioner to file affidavit in reply to the opposition filed by the state respondents.
There's one mistake committed, that the affidavit is affirmed, but the annexure R1, which is supposed to be part of the affidavit, it is not with the affidavit.
What is R1? The deed?
R1 is not the document showing which parties have completed the biometric. It's a printout from the system.
All right.
I'll just annex that and I'll hand over.
Has copy been given to you?
Yeah, earlier one has been given to me.
R1 is not there.
R1 is not
there.
He'll forward R1 to you.
Complete it and forward.
Achha.
Let him use the reply.
কি বললে মেটা ডেট দিলাম কি রিলিস্ট হ্যাঁ না তারপর বললাম না by 14th of February 2025 is it affirmed? Is that copy affirmed, Mr. Banerjee? Is that copy affirmed?
Copy is affirmed, my lord. Copy is affirmed, but R1
All right.
is not there. That is why I am not filing it, my lord. I can file another copy. Let it be on record, but I'll file another copy because it is the affirmed copy of the stand. Stand will not change, only the annexure R1 shall not come in the subsequent.
Achha, the annexure to the affidavit in opposition of the state respondents.
But an opposition is an affidavit.
Achha, ঠিক আছে, affidavit of the state respondents. কেটে দিলেন কেন? কি বললাম ওটা? হ্যাঁ, annexure of the affidavit of the state respondents be handed over to the court on the adjourned date. Stop. Let a copy of the annexure to the affidavit be served upon the learned advocate representing the petitioner immediately.
Petitioner
affidavit containing the information as required by the recruitment has not been extended some of time to complete it.
Lordship, directions were passed December 19.
That's what I'm not disputing about that for the date and the direction of it also. By 500 of our society. It is in respect to information.
Yes, yes. I can see the order and I can recollect what is there. 19A, 19 by 1B.
Particular 19A and 19B ballot there. The same ballot does not exist, and or the certain by numbers are there depending on the RTR. That
Will this information with this affidavit help you?
My lord, it will help me certainly insofar as I can then take it up further, because some responses are saying Thika property.
They explain it in your affidavit.
That was my lord's previous direction, that the explanation be put on affidavit.
It may not possibly that is wrong, because it is the matter about the exclusively dealt with by the.
If your authority furnishes wrong information,
not wrong in the sense.
I do not know wrong or right, your authority will understand. On the prayer of the learned advocate representing the corporation, time to file the affidavit is extended till what you will explain, I do not know.
I am opposing the prayer for 2 weeks, my lord.
12th of February, released on 24th.
Deeply obliged.
Yes, number 1.
My lord, item number 1, I appear for the petitioner lordship. Due to inadvertence, lordship, you missed out certain documents in the matter, and also pleadings are required to be amended because of subsequent events. I'm praying that the matter may be allowed to be withdrawn with liberty to file afresh, my lord. I also have a copy of the letter given to me by the client.
Yes, give. Very well. Incurable defects dismissed. Leave to file afresh.
I'm deeply obliged, my lord.
The written instruction be written with the records.
I appear for the petitioner.
May I file my
This is for
the report?
till Lordship had passed an interim order till today on 20th January.
Did you get the copy of the report?
I have just got it now.
Just now, you
I will have to use an exception to this.
have to use.
I don't know what they. I have to.
Yes.
Clinical Establishment Acts, my lord. It has been specifically mentioned, my lord, that they have to produce the documents with regard to their tenancy or whatever. My lord. I just hand up to this document, my lord. This is what, my lord, a notice has already been given, my lord.
And I tell your lordship, the Malafites. Your lord, there are two firms. One is a tenant. I am a subtenant under that firm. The partners are common. Last year, the attempt by the landlord was to involve the KMC and issue a notice for demolition of the building so that I am thrown out. This year, first, my renewal application under the PNDT Act. Now, yesterday, we've been served with a notice under the Clinical Establishments Act in respect of a license which has been renewed in 2023 and is valid till 2026, which they propose to now reopen. So it is all coming from the same source, my lord. That is why I knew what will come in this report. Kindly permit me to bring these facts on record. I have submitted to them a tenancy agreement. Whether I am a permitted subtenant, valid subtenant, I am in possession, my clinical establishment license has been there since my inception at the same premises. This is a firm that is running since the 1990s.
As per Clinical Establishment Acts, my lord, a person, my lord, intending to commence, my lord, kindly see A, B, and C.
You have the rent receipt with you?
I have
Or
the rent
challan?
agreement. I have the rent agreement.
He has all these documents.
He
Nothing has been produced in the
Where will you go through whatever is there in the report? Please come. Report filed on behalf of the respondent number 3. In court today is taken on record. Stop. Copy of the same has been handed over to the learned advocate representing the petitioner in court. Stop. The petitioner intends to file an exception to the same. Achha. Time to now let exception to the report may be filed by 12th. Will be all right
Yes,
with you?
Yes, ma'am.
Released on 25th. The interim order that is subsisting in the matter is extended until 31st of March 2025 or until further order, whichever is earlier.
Obliged, my lord.
Yes. You can keep that document with his lordship record, my lord, so that on the next time, my lord, when I argued, my lord, this document, my lord,
It is only the act, isn't it?
The act and the rules.
Oh, there is an instruction also. The instruction forwarded by the OSD and Deputy Secretary of the Health Services within bracket admin dated 27th January 2025 be written with the records.
Obliged.
In this matter, my lord, your lordship, I have filed an application for injunction as because during subsisting of the interim order, they have issued the tender. Your lordship disposed of the application and as per pair of my learned senior friend, your lordship directed the matter to be remain in the list of
regular basis.
list of
Possibly it has been wrongly appeared. Yesterday, the application was disposed of by your lordship with the
See,
direction
hearing
that
matter?
since the matter was interim order is subsisting, the matter was there in the hearing list. It was appearing as item number
4.
So
এটা লিস্টে দিলেন কেন?
State respondent, my lordship, late
Well,
by Mr. Garland.
Item number 4, your lordship, I beg to appear on behalf of the petitioner. My lord, unfortunate thing is this, my lord, petitioner's son, petitioner 71-year-old, has some neuropsychological medical complications.
Who are you for?
For the state respondent, my lordship, late by Mr.
My lord,
Garland.
simple prayer, my lord, any steps so that he can be admitted in any state hospital, preferably Pavlov.
Pavlov.
My lord,
What is your submission?
My lordship, I have the report, my lordship.
Please give.
Lordship, we have taken all the actions. He has sent some representation. We have taken actions for the representation.
What action have you taken?
My lordship, we have
Psychiatric
In
illness is
para-
chronic and require consistent familiar support.
advise him for the OPD to the Calcutta Pablo Hospital for excellence of mental health and along with the patients, all the related medical documents we have, my lordship.
Wait, the Pavlov hospital has opined that the patient could be managed with OPD and familial support. See, it is the doctor, the expert body is saying so. Your saying will not do.
May I submit only one thing in that regard? He was admitted in a private hospital where I cannot afford. Page 19 of my petition.
Yes.
Kindly. This is against his personal, my medical bond. Discharge against medical advice.
Everything is mentioned over here. The OPD ticket, the patient was diagnosed with schizophrenia, borderline personality disorder, prescribed appropriate medication. Everything is mentioned. But the doctors opine that the outpatient department is all right.
My predicament is this, my lord. How could I bring my son to the hospital? It is not possible to bring him. So much aggressive.
Oh, what can be done?
But some kind of paramedical staffs are available at some assistance for 2 weeks or 3 weeks at least. Let the medication starts. Situation be improved. Presently is without medication. Paramedical staffs are available. Some assistance. Neighbors are also refusing to assist because if the neighbors come, he is so aggressive. He attacked the neighbors also. So some assistance on the part of the paramedics or any other assistance. I am ready.
Please come.
Lordship, report, my lord, handed over.
I have seen.
Lordship. My lord, he was sent
Report
to
of
the
the
sent
Chief
to this
Medical
Pavlov.
Officer of Health, South 24 Parganas, signed on 17th of
Kindly see
January
the last annexion,
2025.
last page of the instruction.
Is taken on record. Stop. The petitioner is the father of what is the age of the
41. Shamul.
The 41.
40.
Is
My age is 71.
The petitioner, comma, a 71-year senior citizen, is an unfortunate father of a 41 years old neuropsychological son whose physical and mental condition is deteriorating day by day. Stop. The son of the petitioner is suffering from severe mental imbalance and associated medical complications. Stop. The father desperately wants his son to be taken care of in any government hospital as he is financially not well off to get him treated in any private nursing home. Stop. He made a request before the Chief Medical Officer of Health, South 24 Parganas, for providing medical help to his son. Stop. Paragraph. As there was no response from the end of the CMOH, comma, the instant writ petition has been filed. Stop. On a perusal of the report forwarded by the CMOH, it appears that the authority has opined that the psychiatric illness of the son of the petitioner is chronic in nature and it requires consistent familial support for recovery. Stop. The officer opined that home-based domiciliary treatment is recommended.
May I, Lordship, he was sent to OPD.
Attending doctors of the Calcutta Pavlov Hospital, where the petitioner was, the petitioner's son was checked in the outpatients department, concluded that admission was not required and the patient could be managed with care and familial support. Paragraph. Learned advocate for the petitioner submits that his son becomes so aggressive at times that it is not possible to administer medication to him. Stop. Regular complaints are being made by the neighbors, and it has become absolutely unmanageable for the petitioner to keep his son in his house. Stop paragraph. Though on a perusal of the report of the CMOH, it appears that the patient can be treated by his family members. But as it has been submitted that the presence of the patient in the house is creating serious issues with the family members and also with the neighbors. Accordingly, the court thinks it fit to direct the CMOH to find out a solution to the problem that the petitioner is facing in keeping his son in his house. Stop paragraph. The CMOH is directed to explore the possibility of getting the patient admitted in any of the government hospitals where medication may be administered to the patient so that he may recover to some extent, after which he may be taken home. Stop. The paragraph D, the learned advocate for the petitioner submits that it has become practically impossible for the petitioner and his family members to take his son to the hospital or before any other medical authority for treatment. Stop. In such a situation, the CMOH is directed to render all assistance to the petitioner to resolve the issue. The matter is adjourned till 17th of February 2025, when an updated report shall be placed by the CMOH on the adjourned date. Stop. It will be open for the CMOH to send personnel to the residence of the petitioner to see that he can be taken to any hospital for treatment, for admission, for providing treatment. See what can be done,
Lordship, I fully appreciate it.
what to do.
Lordship. Lordship, I should talk to him, Lordship.
Most obliged.
Sorry, petitioner. Then you might also need to file the affidavit of service minute. But these are those matters where we were seeking the differential determination and interpretation of Railway Board circulars. Millets was pleased to pass an order. The order which was passed by my lords on 6th November 2024 millet is at page 178. May I place on and from paragraph 5 minute? From the documents annexed to the writ petition, it appears that similarly placed contractors were given the benefit of the subject circulars and substantial number of days has been extended after the end of the contract period, whereas in the case of the petitioner, only 68 days were treated as dies non. Where the first circular was with regards to applicability and
is the instant writ petition in continuation of this order?
Yes,
Or it's a fresh one?
Continuation of this order. Now, thereafter, it appears that on one hand, the authority accepted the period calculated by the divisional authority in accordance with the railway circulars, and on the other hand, mentioned that circulars are not applicable in respect of the petitioner. The stand of the senior divisional commercial manager appears to be contrary to the one taken by the divisional authority. According to the Railway Board circular of 21st August, the relief in charging license fee after dies-on period was to be considered.
Yes, there was a direction for revisiting the
kindly
issue.
have a look at paragraph 11 minute.
Yes.
And then 15 and 16.
Right.
So
What
the
happened
basis
thereafter?
What
happened thereafter?
The basis on which Millard had sent me back to the divisional manager was that the extension given to other people was to be considered. Now, Millard, I went there. The hearing was concluded on. The hearing was given to us on 23rd December 2024. Thereafter, after the stipulated period given by my lord on 13th January, they passed an order. The order, Millard, is at page 192. Now,
What is the conclusion?
Yes, the conclusion is that we will not grant more than this period.
Right.
And they have not revisited on the issue of the contractors, other contractors being given extension. Now, will kindly bear with me and take page 193 once, Millard. At page 193, Millard, the senior divisional manager has spoken about he has mentioned 3 circulars, basis which the determination has been made by them. But I had personally attended the hearing, Millard. Though, Millard, it was said that there were other circulars, Millard, in the file or during the course of the hearing, these circulars were not surfacing. The only circular which was there was 21st May 2020, which is at page 100, Millard. Then, Millard, will see brief history that I am reading from V-Day Board's letter.
No, but then what's the use? This is a reasoned order.
No, Millard, they have not touched the aspect of why others have got 593 and 494 days and not me.
Well, they'll explain it by way of an affidavit. What is to be done?
Now the difficulty is that I have been forced to close my stall.
What can be done?
Others are getting it. When others are getting, why not? Will bear with me. I'll just demonstrate by two annexures as to whether at all. Just two communications.
Later finish, then I shall start.
Yes, it will go on. Cannot be done.
Just 2 letters. Only 2 letters.
My lord, they are taking advantage of this. Initially, my lord, kindly, my lord,
only 2
allow me, my lord, 1 minute. My lord, kindly allow me 1 minute, and then my lord pass the order. My lord, in a similar case of Shialda, my lord, pass an order disallowing their claim not to run the show. They have to close. They preferred appeal before the division bench. My lord, see the order of the division.
So the facts were different. There they said that I was asking for 441 days. They said you sought for 231 days. I gave you 231 days.
Lord, they preferred appeal before the division bench and see the order of the division.
No, there the number of days were categorically mentioned. I told the court that I had not sought for this number of days. I had sought for more days. And that is what the court held, that because you
The
sought
order,
this-
please come,
but
the
this
order
was not
passed by
same.
the Senior Divisional Commercial Manager, Eastern Railway,
They have not
Asansol
revisited the issue at all.
on
but I'll
13th of
I'll
January
place the entire order.
2025.
While only one
Rejecting
paragraph,
the
my lord.
prayer of the petitioner to hold on to the stall is impugned in the instant petition. Stop. The petitioner has been requested to vacate the possession.
Others similarly placed next door, Millet is staying for 594 days.
The petitioner submits that the recent order has been passed without complying with the direction passed by this court. Stop paragraph.
But considering page
Learned.
166, 167, 168.
Discrimination has been pleaded. Eta thakbe. Discrimination has been pleaded. For a paragraph, learned advocate representing the Eastern Railway opposes the prayer of the petitioner. Stop paragraph. It appears that the order impugned is reasoned one. Stop. Validity of the reasons is required to be adjudicated after granting opportunity to the respondents to file their opposition. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing upon completion of the aforesaid time period.
My lord,
There is no scope for granting any interim order in this matter at this stage.
my lord, I have to take initiation for auction, my lord.
Then how
Kindly see one paragraph of that order.
Then how will the auction take
One
place?
paragraph 9 and 10, my lord.
Of which order, Millet?
This is division bench against the order of this court.
No, that are different facts and circumstances, Millet. No, those.
All right, you proceed. The court is not stopping you.
Yes, that
Millet,
my lord,
Millet,
I can
Millet,
proceed
kind-
for auction.
Millet,
They can,
others-
they can.
Millet, others
what is-
will. Others similarly placed
Milord,
vendors
seven,
will
item number
enjoy
7 also
500
same,
days.
my lord. Item number 7 also same.
1 minute. I'll go to 6 first, then 7.
Millet, others will enjoy 593 days. I am given only 68 days, not even 90 days, Millet.
Yes, item 6.
And Millet, we've continuously paid the license fee.
Item number 6 and 8 are similar matters, my lord. I'm led by Mr. Parthasarathi Sengupta, my lord. I had mentioned this matter, but yesterday I have been informed that he is indisposed, my lord. He has throat infection. He is not able to appear online also. And may I pray that the matter may be fixed, my lord, on the next week, preferably on the Wednesday, if
Then
possible.
Friday, my lord. Friday.
But in the other matter, Mr. Bhattacharya is appearing, my lord. Item number 8.
Next Friday.
Friday পারবে?
No, Wednesday.
কিশোর 5 তারিখে কর।
এই বিকাশ দাও তো একই কথা।
হ্যাঁ 5 তারিখে কর।
5 তারিখ।
Bid open করো 5 তারিখে।
But Wednesday first half মিলো
হ্যাঁ ফার্স্ট হাফই হবে।
ঠিক আছে। First half.
I cannot assure.
If it retains his position, it will be taken up first half.
The court's proceeding are in none's hand, neither the judge nor the bar.
Consent of the parties, let the matter appear in the list on 5th.
No, it will retain its position.
Retain his position, Milord.
Yes, urgent
But
motion
in
will be
case
there.
where it's not
Okay.
taken up in the first half, kindly accommodate Milord, in the
Sure,
second.
sure.
I'm grateful. Okay.
No.
But in this matter, the reasoned order which was passed beyond the stipulated time, giving me only 68 days, Milord.
Is the date of the order same?
No, Milord, the date of the order is not same. Milord, the date of the order is the 30th September 2024.
You have already get 138 days.
Which page is the order?
At page 96 is Milord's order. And the impugned order is at page 104.
10.
Please come. Item number 5 যেটা হলো impugned order is date হচ্ছে 13th of January 2025. Same order. Yes, 8. It is the same, possibly 8.
I'm obliged.
Same as 6.
Well, this is my application. We are challenging a
Allow us
prohibitory.
to come back at 2 minutes. Landed government leader is leading him.
Why two?
I mean, next week we'll have done.
Well, next week is difficult, madam. There is a prohibition order against me.
Let us see what is there.
Yes, ma'am.
Hello, Malal, kindly accommodate me. Either 2 or Milord next week, Malal, kindly. When it is
2 o'clock is not possible. I do not fix time.
then allow us to come back next week, Malal.
You see, there is an opposition.
My lord, will kindly take the prohibition order, which is the subject matter of challenge in this writ petition at page 95.
95.
Uh, 1912.
May I just take your lordship to the order? This order has been passed by my lord the designated officer in exercise of the powers conferred under section 36 3B, read with section 18(1)(g). Now, my lord, may I just read out the order? Whereas a sample, namely the top, my lord, the biscuit involved, the product involved is the top biscuit, 200 gram collected by food safety officer so and so under section 38(1)(a) and section 47 of the Food Safety and Standard Act 2006. Vide so and so. The date may kindly, your lordship may kindly take 26 September 2024 from Mr. Saroj Saha, Srishti Food Shop so and so, West Bengal, and submitted to the food analyst for analysis according to section 47 of the Food Safety Standard Act, read with section 2.4, well, that is regulation rule 2.4 of the FSS rules. Whereas upon analysis of sample by food analyst, according to section 46 of the Act, read with rule, it should be rule 2.1.142 of the FSS rule 2011, it has been opined that the food analyst, by the food analyst, that the sample is unsafe. This is very important. Sample is unsafe as per regulation 2.4.151 FSS. This is Food Safety Standard Act, Food Product Standards and Food Additive Regulations. This is an acronym they have used, but the regulations is like this. Therefore, under section 36 3B of the FSS Act, you are hereby directed to stop manufacturing and or sale of the top bearing batch number so and so, packaging so and used by 23rd February 2025, read with section 18(1)(g) of the FSS Act on immediate effect. This order is issued in the public interest of public service. But I do not understand how the interest of public service, generally we come across this expression in transfer orders, in the interest of public service. So, the first point which emerges is that the authority concerned, the designated officer, appointed under section 36 3B, has passed a prohibitory order in exercise of the power conferred under 36 3B. Now, if your lordship kindly takes the report on the basis of which the order has been passed, which is at page 98, which was forwarded by a memo dated 10th January 2025 to the petitioner. Kindly take the report which starts at page 98.
Yes.
Certified that I so and so, this is issued by the Office of Public Analyst, Food and Water, West Bengal Public Health Laboratory, 2 Convent Lane, Kolkata so and so. I so and so, duly appointed under the provisions of the Act for the state of West Bengal, have received from the food safety officer so and so sample of the top bearing code number so and so of the designated officer of Murshidabad district on 4/10/2024. Date of receipt of sample for analysis. My lordship will find the date of collection is 26 September 2024. Date of receipt is 4th of October 2024. Then, my lord, the condition of seals in the container and the matter is receipt as follows. The sample is packed and sealed as per rule 2.4.1 of the FSS rules. The seals are found intact and unbroken and tallied with the specimen impression of the seal sent under rule 2.4.1(11) of FSS rules 2011, intact, damaged, missing, we delete wherever applicable, inapplicable. They are not deleted, whatever. I found the sample to be biscuits category of the sample falling under regulation number 2.4.151 of the FSS Food Product Standards and Food Additive Regulations 2011. The sample was in a condition fit for analysis and has been analyzed on 13/11/2024 to 14/11/2024. So, my lord, the collection date is 26/9. The receipt of the sample was received on 4/10, and ultimately the sample was analyzed on 13/11. And category is biscuit under, my lord, falling under 2.4.151. Now, my lord, now kindly come to the analysis report. My lord, I am not taking your lordship to the merits or demerits of the report. Kindly take the first page, my lord, 98 itself. Well, at the bottom, your lordship will find all above parameters under the scope of NABL accreditation as per ISO so and so, so and so. So this part of the report is as per the accreditation which is given in favor of which this agency has, and this accreditation is given by NABL. Now, my lord, kindly come to the second part, page 99. But this is where, my lord, the report, otherwise, on the basis of which, my lord, the order has been passed, is contrary to the regulations. Kindly take, my lord, 1. My lord, under the table 1, extraneous coloring matter. FSSI manual, tartrazine, and bakery and confectionery products, so and so. Now, my lord, kindly take the opinion. The sample of the top bearing code number does not conform to the standard of biscuits as laid down in regulation 2.4.151 of FSS, FPS and FA regulation 2011 due to presence of non-permitted color tartrazine. Hence, the sample is unsafe. So, my lord, the opinion of the food analyst is the sample is unsafe because it uses what? Extraneous coloring matter. And, my lord, it is on the basis of this opinion, the designated officer has passed the prohibitory order. My lord, the law is such, my lord, section 46 confers power on the food safety. Kindly take the book, my lord, kindly take. Because I am on jurisdiction now. But I know, my lord.
Jurisdiction of the?
Of the, my lord, the designated officer. And also, my lord, I am also challenging the order on the ground. My lord, no opportunity was given to the petitioner, being a, my lord, a food manufacturer, to controvert the findings of report or carry the report to the appellate authority. And before that process could be concluded, my lord, the prohibitory order has been passed.
No, but then, see, this is concerning people's health.
Yes,
right?
certainly.
The report of the food analyst is the sample is unsafe
for what?
For human consumption.
For what, my lord? For extraneous coloring matter.
Right.
My lord, kindly take first, my lord, definition of extraneous matter, which is as per the Act.
No, but then you say there is an appellate authority. Why did
My lord,
you go over there?
my lord, may I just take your lordship? There is an appellate authority against the test report. There is the prohibitory order, or the order of prohibition is not applicable under the Act.
But the prohibitory order is a consequential order.
Yes, my lord, no, it's not a consequential order. My lord, the designated officer has to apply his mind to the test report and form an opinion. Because this is a, my lord, order.
Once you get an analysis report which says it is unsafe,
Yes,
what
my lord. And my lord,
further
kindly take,
application
my
of
lord,
mind
the
will be there?
The remedy of appeal would be illusory because the appeal would lie before the designated officer himself. That's the law. So today, the designated officer has passed the prohibitory order. Even if I prefer appeal against the, my lord, this test report, the appeal would be before him only. And that is 46(4). Kindly take section 46(4) for once. But that is why, my lord, some of the provisions may I take your lordship too. And I would demonstrate that the, my lord, that the officer, designated officer, is required to apply his mind to the report and form an opinion. Because, my lord, this is an order entailing adverse civil consequences. Kindly take, my lord, the first section 36.
Is it the same book that you?
Yes, my lord, page 36.
Page 36.
Page 36.
Yes.
Now, my lord, kindly take, my lord, section 36.
Right.
My lordship will take subsection 1 first.
Yes.
The Commissioner of Food Safety shall, by order, appoint the designated officer who shall not be below the rank of an SDO to be in charge of food safety administration in such area as may be specified by regulations. Then, my lord, I am skipping subsection 2. Kindly take subsection 3. The functions to be performed by the designated officer shall be as follows. My lord, kindly skip A. Kindly come directly to B. Prohibit the sale of any article of food which is in contravention of the provisions of this act and the rules and regulations made thereunder. So, my lord, this order has been passed in excess of section 36B. Now, my lord, kindly along with, and my lord, kindly take the order. The order says stop manufacture and sale. 36(3)B does not empower the designated officer to stop manufacture. So this is first ground that the officer has acted beyond jurisdiction. The law does not permit him to issue a prohibitory order prohibiting the manufacturer from manufacturing a food product. Whereas the order reads, my lord, it is stopping of manufacture and sale. Kindly, my lord, read along with this, my lord, the impugned order. Page 96, your lordship, page 95, your lordship will find the impugned order. The direction is stop manufacturing and or sale. Last but one paragraph.
Your license has not yet been cancelled.
No, nothing. And my license is for manufacturing fine bakery items. But there is a specific code allotted to me. Code is, my lord, 7.2.1. Under 7.2.1, I am having a license, but there is a software mechanism maintained by, my lord, this FSI, my lord, Food Safety and Standards Authority of India. This software is known as, my lord, FOSCOS. My lord, in the FOSCOS software, your lordship will find, my lord, the documents that I'm holding the relevant that this kind of goods, my lord, this kind of product will come under the category of 7.2.1. My lord, the wrapper which I use, my lord, obviously the biscuits come with in a wrapped mode. But the wrapper would indicate that I'm using this color because, my lord, there is a code allotted with respect to a particular color. The code is, my lord, 102, right? Yes. 102. And this corresponds to color, namely tartrazine. But this is that yellow sunset yellow color, tartrazine, which is permissible as per the rules in respect of, my lord, category of food products under 7.2.1.
7.2.1
of the, my lord, the FSS.
Yes.
Food safety and standards.
Right.
Food product standards and food additive regulations 2011. Now, my lord, kindly take, my lord, the appellate remedy against the state's report. Page 43. Page 43 of the book. Kindly take subsection 4. Section 46. Of section 46.
Yes.
An appeal against the report of food analyst shall lie before the designated officer, who shall, if he so decides, refer the matter to the referral food laboratory as notified by the food authority for opinion. Well, I have also annexed documents, test reports, test being conducted by an competent authority appointed by FSI, where, my lord, this class of biscuits, my lord, there are, my lord, just for example, my lord, the biscuit involved here is now the top. My lord, similar, my lord, color identical color, that is tartrazine, is also used for the manufacture of, my lord, petit beurre. This is another class of biscuit, and top herbs, and the spicy chatpata, something like that. Well, in all those cases, the laboratory or the food analyst has come to a firm opinion that the said biscuit or the food products or the additives used in the said biscuits are in conformity with the regulations, including tartrazine. I have annexed these reports, your lordship, 109. But this is, my lord, one fine morning, a food inspector goes on a shopping spree, picks up a biscuit from the market and sends it to the food analyst for a report to stop manufacture and sale of these goods. So, my lord, today I have demonstrated before your lordship that the appeal would lie before the designated officer. So, the remedy of appeal would be illusory. It will be not only, we use the expression Caesar to Caesar's wife, this will be from Caesar to Caesar himself.
1 minute. Yes. Who will be the appellate authority?
Look, this referral is.
Referral is different, but who is the appellate authority?
Will kindly come to page 96.
Yes.
First of all, my lord will kindly accommodate me some time. Learned government pleader wants to argue. I am trying to assist your lordship in such time. Page 96, my lord will find. Look, I'll start with what my learned senior friend started, saying he doesn't understand, he doesn't appreciate how public interest is involved.
No, don't have to address that. You tell me who is the appellate authority.
My lord, section page 96 says so. Kindly take page 96. Kindly take page 96.
To the designated officer.
Yes, as per
Within
section
a period of-
46(4),
Yes.
you are informed that if you desire to appeal against the report of food analyst, make an application in Form 8 of the FSS Act to the designated officer, Food Safety, Murshidabad. And my lord, who has signed the order? 95, the same officer?
He is the district inspecting officer.
He is the designated officer for the district of Murshidabad.
And the designated officer. How can the appeal lie before the same authority?
This is, my lord, limited to the function of the food analyst. Look, he will not adjudicate the matter. There's a difference between two, my lord. His role ends to the analysis of the food. Section 46, my lord, will kindly see.
Who is the appellate authority?
Look, at this juncture, my lord, there is no prosecution. Lord, we have found some food, some biscuit to be carrying some
unsafe for consumption.
That is unsafe.
Right. Now,
the law provides, may I take one minute from your time? Look, the law provides an opportunity to the manufacturer to send it for a second testing to ensure that the substance, the first test has detected, the second test also detects the same, or the said substance is present in
under which provision?
Milord, this is 46, my lord, will kindly see.
46
and 46(4), my lord.
46(4) is the appellate provision.
It is the appellate provision limited to the fact or the analysis of the food.
Very well. Now, you say there is a provision. In fact, this provision also says there is a scope for referral. Who is going to refer? You or the party concerned?
The party concerned will accede to the referral, and the food will be, the sample will be.
Did you pass it on for referral?
Second testing.
Did you pass it on for the second testing?
They are not participating therein.
What is his role? You have the sample with you. You will send it for referral.
If we have to provide this 46(4),
yes,
is that we have to provide him an opportunity for referring the food to a second analyst. Right. If he doesn't give his response to within the 30 days, we will start the prosecution. And the prosecution will be held in the district court.
No, that is different. We are not going to that stage. Page 95 is the prohibition order.
My lord.
So he has been prohibited from manufacturing as well as selling. He is aggrieved by this. What is his remedy? And where does it go?
It is the act concerns the public health. What is
Yes.
so even if I am, at times 19(1)(g) and these things has to be kept aside when public health is concerned. If the district food analyst has come to a finding that a biscuit is containing something which it is not supposed to contain, and it is consequently prejudicing public health, till such time is decided, the manufacturing or sale of that very bad.
Who is going to decide?
The prosecution analyst, the food analyst will deal.
You are not answering the query of the court. A person is aggrieved by this order. Where will he go? This is the only query.
My submission is that it is not an appealable order. There is no provision of appeal against a prohibitory order.
Because the act is such.
So there is no provision of appeal?
Very good.
So the writ court will enter into it and decide?
No, my lord,
Then-
my lord will kindly see this, my lord. The act provides this. Considering the public security, public safety, my lord.
Health. What role do you have to
My
play?
lord, virus has been challenged of 36.
Virus has been challenged.
3B.
36 3B, I stand corrected.
On the ground of
On the
that-
ground which was being pleaded by my learned
Yes.
friend regarding my stopping the supply. So, my lord, in that case, my lord, a notice has to be served, my lord, to the learned attorney general.
We have already served.
I don't know. I was not posted with the facts.
But then do you also have
As far as
food
virus
analysis?
is concerned, then I have a say, because 36B only says that if there is any wrong with the report, the sale of that product will be stopped, which was being pleaded. So as far as that is concerned, if virus of that particular subsection is challenged, I have volumes to say. Because if suppose
No, don't say. We are not going to that.
Well,
Do you have a food analyst?
Well, the report is there. We have annexed.
No, that's the states.
No, I have the central report also. Page 109. Mal, kindly take page 109.
That was not yet placed.
Yes, my lord. Mal, I will take your lordship to that. I'm sorry, my lord. My lord, kindly take, my lord, the wrappers, which will first may I take your lordship to the report instead of beating about the bush.
109.
109.
Yes.
My lord, kindly take, my lord, this is, my lord, the test was conducted as per the direction of FASI. Well, that is the, my lord, the
Assistant Director, Designated Officer.
kindly take, my lord, this is central authority directed for analysis of, my lord, this Biskam Chatpata Spicy.
Yes.
Now, my lord, kindly come directly to page 116. Well, I have two other reports which I have annexed to the supplementary affidavit, and supplementary affidavit has been served upon the state. Not served.
But we have not received any supplement.
I'm sorry.
Mamiyo point.
Whatever, my lord, this is a central report. This is part of writ petition. Kindly take, my lord, page 116. Your lordship will find again serial number 4, Tatrazine, the same color.
Yes.
Now, my lord, kindly take, my lord,
Maximum
the opinion.
100.
The sample conforms to the standard laid down under regulation number 2.4.151 of the Food Safety Standards, Food Product Standards and Food Additive Regulations 2011 and complies Food Safety Standards, Contaminants, Toxins and Residues Regulation with respect to regulation number so and so. The above results of the parameter only to the sample tested is received. So, my lord, identical color, the same color being used for manufacture of biscuits.
Supplementary, food analyst.
In my supplementary affidavit, I have annexed two more reports of the central authority.
Very well.
There are many heads of biscuit. One biscuit is a simple biscuit where this substance is not allowed.
Let us not go into all this.
Allowed.
Is there any scope for a referral?
Lord, we have requested for referral.
Where?
Before whom?
Before
No, no, no.
Before whom?
No, no, my lord. My lord will kindly, what the act prescribes, may I come to that, my lord. My lord, the act postulates, my lord, 46, my lord will kindly come to.
Well, he is referring to referral upon appeal.
Right.
Whereas the regulation also says.
Act is conscious that if there is a something but in the food which can prejudice the safety and security of the customer, the first thing that has to be done is to prohibit that.
You are still not answering the query because possibly you are not aware.
No. We are on a merry-go-round, right?
Yes.
Let me take your lordship to one relevant regulation rule. Kindly take page 82 of the book. They say that only upon appeal being preferred, referral can be made. That is not so.
If you say, if the food analyst of the state health body says that it is not fit for human consumption, it can always be sent to somebody else and possibly you should not object to it.
Look, I am requesting that. My lord will kindly again come to.
Then let the central authorities,
page 96.
let the central authorities check and find out because they are relying upon one of the reports of the central authority where tartrazine has been found to be in conformity with the safety standards.
There are three types of biscuits, my lord. Now we have 3 reports we have produced. One for, my lord, this chatpata spicy, which is part of the petition. One for petit beurre, that is in the supplement.
We want that. I agree to what has fallen from the court. Let it be sent to the referral lab of the
central government.
Yes.
I'm so very good.
Where is it? Where is it?
Ghaziabad. Ghaziabad. I'll give the address. I'll give the address.
There is a central lab. My learned friend is
in Kolkata, somewhere in Kolkata.
EFRAC is there.
IFRAC, what my understanding goes is
not a, I have the
central government authorities here.
Let them say.
Yes.
IFRAC is not central, Millard. In
right.
cases, IFRAC is referred by because the report which they
So
have.
where is your authority?
Millard, must be in Delhi. Ghaziabad must be, Millard. I am not at this stage. I am not.
Address, please.
My officers won't dare to, Millard, give false information.
No, that's all right. True.
Millard, the lab in Kolkata is not a referral lab.
Very well.
Now it has to go to a referral lab.
Very well. Give me the address so that it can be sent for.
Because they are well versed,
Millard, kindly bear in mind, my lord, 2 things, my lord, before your lordship passes.
And just inquire as to how long does it take to conduct this analysis?
My lord, if your lordship.
How long does it take? The time period for conducting?
14 days.
Well, in any event, my lord, I have demonstrated before lordship that this designated officer does not have the power to stop manufacture.
But then, Mr. Mozumdar, since it concerns public health, the court will not permit.
2 minutes of your lordship's precious time.
Not
2 minutes, 2 minutes only.
Wait
only
for some time.
No, only the rules, only the act and rules, only the act and rules. My lord, my Mr. Chatterjee, my lord, kindly bear with me for 2 minutes. Kindly take section 3. Kindly take section 3 of the act. How absurd is the report? I will demonstrate from the act itself.
Let the other report come and say that it is absurd.
1 minute of your lordship. My lord, 1 minute of your lordship's time. Kindly take, my lord, section 3I.
Yes.
Your lordship will recollect from the order. It is stated extraneous coloring matter. Now, extraneous matter has been defined in 3I. Extraneous matters means any matter contained in an article of food which may be carried from the raw materials, packaging materials, or process systems used for its manufacture, or which is added to it. But such matter does not render such article of food unsafe. The report is contrary to 3I. The report says it is extraneous matter, and the law says extraneous matter is never unsafe for human consumption.
My lord, kindly take section 19. Lord, it
19
says-
we will come later, my lord. I have not
No,
placed all the
Lord,
regulations.
even if it is not extraneous, they are
My lord,
not
that is-
permitted to cause harm to public
My
at
lord,
the cost of public.
report is extraneous coloring matter.
My lord,
The authority
test is
cannot make any
appropriately at an
submission
appropriate place,
contrary
not
to
now, my
contrary to the report before your lordship. My lord, they cannot improve the report.
We will not. My lord, is only tested at appropriate time.
Please come.
My lord, the others, my lord, I have annexed the
Like
wrapper.
someone is selling poison, let me sell
Yes.
poison.
My lord, this is a 15-year-old product and my lord, we are selling poison.
15, 20, I do not know. You're not supposed to
Uh,
something you have put in your product.
Please,
I'm sorry, my lord.
not between the two of you.
Must not.
But I have stopped long. Because I know when
My
to
lord,
stop.
what about me, my lord? Is he challenging the virus? I'm only.
My lord, I am challenging the virus only to the extent that I am challenging the virus. My lord, reports will come only to the extent that before such a drastic order is passed, your lordship is aware of the law. Before a drastic order is passed, my lord, some opportunity to show cause has to be given. And my
Alright,
lord,
we'll come to
second-
that later on.
we will come to that later on.
Achha.
Well, we have already served notice upon the learned Attorney General through
The prohibition order under section 36 within bracket 3 within bracket caps B of the Food Safety and Standards Act 2006 dated 10th January 2025 passed by the designated officer within bracket FSSAI bracket close and DFSIO page 95 comma Murshidabad is impugned in the instant writ petition. Stop. By the said order, the petitioner has been directed to stop manufacturing and slash or sale of the quotes open, the top, quotes closed, bearing batch number
Page 705.
within bracket XPW TO2A T0 মনে হচ্ছে হবে একটু দেখে নেবেন তো packaged PKG 24th August 24 and used by 23rd February 25. Stop. For passing the said prohibition order, the designated officer relied upon the analysis report of the food analyst within bracket function dated 18th November 2024. Mentioning that the sample does not conform to the standard of biscuits as laid down in the regulation number, page 99, take down the number. Due to presence of non-permitted color within bracket tartrazine.
My lord, only one submission, my lord. Only one submission, my lord. Your lordship is sending it to Ghaziabad, that's a different thing. That your lordship will do. My lord, so far as this lab is concerned, this lab does not have the accreditation for examining the color. And my lord, the Bombay High Court Division Bench has held that this food analyst cannot travel beyond the scope of accreditation.
That was been notified
And
by
my lord, so my lord, this referral, my lord, at this stage, my lord, it may be examined by any laboratory, but kindly do not take it as a referral. It will be a fresh examination because they don't have the.
Very well. I'm not treating it as referral. I want to see
Yes,
whether
certainly.
it is fit
Yes, ma'am.
or unfit.
And-
Nothing more
yes,
than
ma'am.
this.
And one more thing, my lord.
Law can come later on.
I will
Health is
regard
primary.
only one page. My lord, kindly take page 707 for your lordship's kind consideration. Kindly take page 705.
পাশে 624 টা একবার দেখিয়ে দিন যে ফুড ইউজ এই টেবিলে ইউজ করতে বলছে
My lord, kindly take 2 pages for your lordship's kind consideration.
705.
First, my lord, 624. This is the regulations, relevant regulations. Roman 4.
পেজটা বার করছি
624, my lord.
Yes.
My lord has got
Yes.
See Roman 4, use of food additives in food products.
Yes.
Now, Malad, the relevant table is table number 7. Kindly now take 705.
Yes.
7.2.1 your lordship has got. Kindly turn over and take the next page. Kindly take, Malad, the next page. Malad, your lordship will find just after polysorbates, tartrazine 102.
Is permissible.
Yes.
It is a permissible
For
color.
biscuits.
So, my lord, having regard to these regulations, my lord, the test may be conducted.
Biscuits which are in the form
My
of
lord, they don't have the
They don't have
authority to conduct this test.
Listen, if any this food color is unsafe, it is unsafe whether it is in biscuits, in cakes, in chatpatas, wherever it
We
is.
have questioned this exact. We have put this exact question to our clients.
Yes.
I will appreciate cigarettes. Can we prohibit, stop manufacturing or sale of cigarettes? We cannot.
Only the
It is
repetitive
written over there. So
Written
customers
over
who are buying
color
a lot
peach.
cookies are reading that it has tartrazine with it. Conscious decision they are taking, consuming it. We cannot stop it.
When the
But
central
beloved,
government is
one must not be
regulatory
taken, pay cost at the cost of
But this is permissible, isn't it?
Yes, it is permissible. My food is categorized under this code.
biscuits manufactured by my learned friends client come under 7.1.
My lord, my FASI registration says it is 7.2.1.
Everything.
My lord, let them first say whether they did have the authority to conduct this test on color. They did not have the authority. They have acted beyond their authority against the advisory of FASI. Learned Deputy Sales Authority is here before your lordship.
We have,
কি বললাম?
we have annexed the scope of accreditation in the supplementary agreement.
And we have annexed the scope of accreditation.
Not this. And Britannia also uses biscuits.
Hello, kindly come to 607 for once. It's a very technical thing, my lord. That
Tartrazine.
For that reason,
For
The
technical things,
sample has
this
been
manufacturing is being stopped.
The sample has been held to be unsafe.
And Britannia is being allowed for reasons best known to the state authorities.
No. Britannia and Carly.
Stop.
Yes, yes, we have the we have the wrapper.
Madam,
We have the wrapper.
do not, please do not reply. Please do not reply. কি বললাম? Unsafe. Stop. Achha. The petitioner challenges the jurisdiction of the designated officer in passing the order to stop manufacture and sale of the product. Stop. It has been submitted that the said officer does not have the authority to direct stoppage of manufacturing and sale of the food product. Stop.
He has the authority to stop sale, but not manufacture.
Achha, manufacture.
He has the
sale
authority
টা
to stop sale.
Achha. It has been submitted that the authority which conducted the food analysis does not have the accreditation to do so, to test the food color of a food product. Stop. Next. According to the petitioner, there is no appellate authority, and as the prohibition order was passed by the designated officer, the appeal before the said authority would be illusory. Stop. Paragraph. Learned Counsel has referred to the report of food analysis by EFRAC, EFRAC, in support of the submission that tartrazine is a permitted food color. Stop. Paragraph. A prayer has been made to stay operation of the impugned prohibition order. Step. Paragraph. According to the state respondents, comma, the authority acted under the prohibitions of the Act and the corresponding regulations to pass the said order. Stop. The petitioner ought not to be permitted to sell any product that is unfit for human consumption and not healthy for consumption. Stop. Paragraph. As it appears that that an issue of public health has cropped up in the instant writ petition, the court is not inclined to pass any interim order staying operation of the prohibition order immediately at this stage. Stop. The court would like to get the sample tested by a central agency. Stop. Paragraph. Accordingly, the
May I give the name?
yes. Please pass on. Now, where will the samples be available? Do you have it with you?
What has happened? May I tell you, Lordship? Just for your Lordship, because all these matters will come before your Lordship.
Yes.
Now they have targeted 5 biscuits. Only our company. Huh? And this particular laboratory, which does not have the accreditation, is issuing similar reports and determining that tartrazine is not permitted color, and therefore the food is unsafe for human consumption. This company is being targeted by the state authorities. There are 2 writ petitions before the Lordship, and 3 more orders have come. And this is a process which they have undertaken to take the only manufacturing unit which they have in West Bengal.
All right. Tell me one thing.
Yes.
How do the samples reach this laboratory?
These samples were to be examined as per the regulations. Mr. Chatterjee is so vocal. Within 14 days, tests are to be conducted.
Yes.
Admittedly, the test has been conducted after lapse of 6 weeks.
You have the samples?
No, they have drawn the samples from the retailer. From shop. So,
yes.
for example, from a shop,
right.
Kirana shop.
It is a surprise visit. They go and
they are collecting biscuits which are in market for 15-20 years and giving an opinion that this contains tartrazine.
So how does the samples reach
they
this?
Cannot send it, my lord. It has to be sent from outside.
My lord, then obviously a sample. The law requires sample to be tested within 14 days. Let Mr. Chatterjee say that this is not the law. This is not the law.
Mr. Trivedi, you've gone in a trance. Tell me how
one thing, we are making it very clear. Our products contain tartrazine.
No, it's all right, but whether it's permissible or not,
whether
it's
it's
to be seen.
permissible or not.
Nothing more than this. How many samples?
I am in the crossfire. I'm stuck.
Let them draw fresh samples from wherever they want to take. The central authorities.
Very well.
Not from the state.
দিল্লিতে বিক্রি হয় তো
অল ওভার ইন্ডিয়া বিক্রি হয় ভাই ইন্ডিয়ান রেলওয়েতে বিক্রি হয় তোমার
তারপর তুমি যদি বলো ওই 20 বছর
ইন্ডিয়ান রেলওয়েতে বিক্রি হয় ले लो
কত ले लेंगे
एक्सीडेंट वाला ट्रेन से मत लेना let them draw a fresh sample
but they have to be complied with provision.
What does it say?
It says, provided that in case the sample cannot be analyzed within 14 days of its receipt.
You tell me how the sample is to reach this office.
We have drawn 3 set of samples from
but they must be quite old.
No, my lord, may I read it for your lordship? Allow me to read it, beloved. Provided that in case the sample not being analyzed within 40 my little friend will kindly wait.
Yes, please.
Within 40 days of its receipt, the food analyst shall inform the DO, designated officer, and the commissioner of food safety, giving reasons and specific.
So they are
specifying the time to be taken for analysis.
So they need an extension.
So extension in the hands of commissioner.
Where is that?
Not
Where is that extension in this case?
No, if extension was required at this stage.
But let them draw samples
The-
fresh from the market. They need not draw samples from us.
The
Not from them.
designated officer
And we are
and the
saying
district
Tartrazain is
food
there, only the
safety
opinion.
inspecting officer.
Madam, may I just make one humble prayer?
Yes.
Well, our products contain Tartrazain. Well, there is no difficulty. Well, the FASAI is the top authority. Well, the FASAI is the at the level of hierarchy, it is at the top. So let FASAI take a call whether these kind of biscuits, and it can file a report. Because we are not disputing our
For the report, it has to be tested.
well, we admit, my lord, that our products contain Tartrazain. So kindly
Yes,
a report from FASAI will solve the issue.
Mr. Trivedi.
We say, my lord, we say.
We discuss the ingredients also.
My lord, as far as
Presence is
FASAI
there.
is concerned, my lord, we are not representing FASAI.
এই সর্বনাশ
হ্যাঁ, আমি করছি না, আমরা
তো
তো-
কে করছে?
You are there. Where is here? Do you have any officer here in Calcutta? No.
We are okay for providing a report.
Yes.
No, that is all right. But then you have to test it, isn't it?
But the retesting authority is in Ghaziabad.
Testing authorities. Then how will you file a
Well,
report without the analysis or the testing being made?
We pray for a retesting because that is the provision.
That is
given
the
in the
provision,
Act.
my lord.
That means a test has to be done.
Why it is required?
Acha, the designated officer bolen to the respondent number 7.
But my lord, kindly
He is
record, my lord, that
directed
our statement is that our
is
products
directed
contain
to
Tartrazain.
collect fresh sample
Or I will ask
of
FASAI,
the
FASAI.
subject biscuit
communicated to
FASAI.
and forward the same
So why don't you
I don't know what
submission?
to the National Food Laboratory at address ta likhe neben for testing the same
They are not.
stuff. Next, the test report shall be placed before this court
My lord.
on the adjourned date.
My lord.
Stop. List the matter on 19th of February 2025. 14 days
Kindly
is
an early date, my lord.
14 days is the testing
My lord,
time.
14 days, my lord, kindly take, my lord, if they draw the sample, your lordship will find from the report. It only took 2 days to complete the testing from the report which has been annexed.
But then if statute prescribes 14 days, so I'm keeping,
Maximum limit, my lord.
I am keeping that 14 days. Today is
14 days will take us
31st.
to, my lord, 14 days will take us to 14th,
14th,
of February.
yes, that is the reason I'm keeping it on the 19th.
My lord, kindly, or my lord, your lordship, subject to your lordship's kind consideration. My lord, report may be placed before your lordship, my lord, but my lord, the report may be also sent to FASAI to form an opinion in the meantime.
Very well, that can be done.
Your lordship can do that.
My lord, one indulgence, my lord will direct, my lord, that the learned Registrar General of this Honorable Court communicates it with, because FASAI is the authority. We are Union of India. Now, FASAI is not, I don't know what submissions they are making, is neither here nor there. If they take the responsibility of communicating this order and getting it done, then if they vouch for it, then it's okay. Otherwise, my lord,
it is you who will communicate to the central authority. The National Food Laboratory is your laboratory.
My lord, I
It's
shall.
not the FASAI's laboratory.
We shall do it.
And my lord, on
We
the
shall.
19th, my lord, along with the report, the opinion.
Very well.
Yes.
Acha, the test analysis report of the National Food Laboratory shall be forwarded to the Food Safety and Standards Authority of India, being the respondent number 3, for forming an opinion. Stop. The opinion of the respondent number 3 shall also be placed before this court on the adjourned date. Have you followed what is to be done? Did you file your wakalatnama?
Yes, madam, absolutely.
All right.
Market is not.
These samples will be collected by the respondent number 7. It will be forwarded to the laboratory.
Yes.
Laboratory will take the report.
It's from Delhi available.
This report will go to you.
Absolutely.
You will form an opinion and send it here. So here there will be two things, your report and the food analysis report of the National Laboratory.
These biscuits are available all over India.
No, no, my lord.
All over India.
Let us draw from here. Yes, we have tested.
So that, my lord, the color may have a different color from Bengal. A different color from the state. A different color for the state, different standards set for different parties.
Bengal's biscuit tasted.
All the parties are directed to take prompt necessary steps for compliance of the direction passed herein above. Stop. The now health being the primary concern, comma, the authorities shall ensure that the direction passed herein above is complied with within the time limit prescribed.
Lord, we will draw the sample fresh.
No, you will not draw.
Fresh sample.
Number 7 will draw. You will not draw.
Fresh sample, respondent number 7.
Draw the sample for this purpose.
May I understand?
No.
আরে আমি জজের যেটা বলছি শুনি
Respondent number 7 is going to draw fresh sample, forward it to the National Testing Laboratory, who will conduct a test. The test report will go to FASAI. The report of analysis report will come before this court. The report of FASAI will come before this court.
We are grateful.
Yes. Grateful, my lord.
Affidavits of service is taken on. Supplement. What is the supplementary that you have filed?
The 3 test reports from central authority
and scope of accreditation.
and the scope of accreditation.
Circulate.
Yes, we have already.
Keep that inside.
Well, it's a classic case.
আপনি এটাকে রেখে দিন, ওরা এটাকে পরে দরকার লাগতে পারে।
Whenever the respondents have to countenance these kind of matters, well, they take that plea of public health, etc. It's to invite that it's a kind of judicial hands-off policy.
We have learned from our learned senior friends.
Yes, call the next one, please.
Affidavit of services.
Supplement রাখবেন. Supplementary.
392 and 390.
Well, affidavit of service may be taken on this.
1912 দুটো আরো বলে দেন না, ওই সেম অর্ডার হবে না। The other two.
My lord,
Other 2 matters.
there are 2 more matters. Same order may be passed in those.
And is the biscuit top?
No, the name is different.
Name, not top.
One is top herbs and one is googly.
One is top herbs, one is googly.
তাহলে তো ওটা which is the item number?
Item
number 390.
Give the item number and the commodity.
392 and 395.
And check up whether the respondents are also same or not. 392 and
give me
395.
What we will do, my lord, we will give the number and the commodity. Best.
We are grateful, my lord.
But we have to do our business in some other state.
May we get back to book, my lord?
That will be sad.
But this is now becoming,
That will be sad.
sorry to say, this is becoming a state of despair.
My lord, may I get back the book?
I would have been,
বইটা ফেরত যাবে।
my lord's leave.
Mr. Trivedi, play your role, please.
My lord, I will.
Otherwise, it will be difficult.
I know Mr. Trivedi since my college days.
His hands are long, strong, my lord.
He is the best
Whatever.
person who knows all the tricks not to play with.
My lord, a friend, his motto is a friend in need is not a friend of mine. I'm grateful, Miller.
10.
Then Lashmi, I appear on behalf of the rest number 2 and 3. Lashmi, I have taken instruction as my learned senior friend has pointed out that in the tender document, the 10 minutes time is mentioned. Now, Lashmi, it is the policy of the, or rather the practice of the NIC. We have obtained a short instruction, written instruction from NIC. The practice of NIC is when the time is fixed for closing. In this particular case, it was fixed 6:30 p.m.
No.
No.
It was not fixed.
No, Lordship, there is a time limit. If your Lordship kindly appreciate the schedule as mentioned in the tender document.
Yes.
At page 23, this is the tender, subject tender. Lordship, the 3 column from the bottom, end of electronic auction, it was fixed initially till 5 p.m.
One
Page
minute.
20.
Let me see. Yes.
See the third column from the bottom. End of electronic auction 20th January 2025 at 17 hours. That was 5 p.m. It was initially when the tender was floated. The time was fixed for till 5 p.m. Now, if your lordship kindly come to page 62.
Prior to that, come to page 42.
It is there. In my tender document, I admit that it speaks about 10 minutes.
Yes.
I am not disputing the submission made by my learned senior advisory. Lordship, it was till 5 p.m. Thereafter, on the day of auction, it appears that it was extended till 6:30.
It was not extended. You are going wrong.
No, Lordship, the procedure is if somebody submit a bid prior to expiry of the 10 minutes, Lordship, there is an exception. The last time slot.
Where is the exception?
Lordship, it is not mentioned in the, it is that.
How will the authority, how will the bidder get to know?
Lordship, it is the NIC who maintains the portal. Lordship, we have sought instruction. They till date, today I have not received. Yesterday, after the order was passed by this Lordship, I immediately asked my client to sought for the necessary written instruction that how these procedures are conducted. Lordship, till morning, they have not communicated it. Lordship, it will take some time. The thing is, as I was informed verbally, that had somebody put any quote amount prior to expiry of 5 minutes of 6:30 in that event.
Where is the 6:30 coming?
So it is there in the summary, auction summary.
Oh, you are going
No,
wrong.
again it will be extended for 10 minutes if somebody puts bid after 6:25.
How do I get it?
Lordship, that's why it will be communicated from NIC.
This is changing the rule of game.
You cannot do this.
Absolutely.
And so
changing
far,
the rule
the
of
second instruction, as your Lordship pointed out me to take instruction that in case there are technical glitches, thus we have taken instruction. If the NIC ultimately reported it to my client that yes, there are admittedly technical glitches, we shall hold fresh auction. That is my instruction.
That is one part.
Yes. But so far, these 5 minutes and 10 minutes parts is concerned, it is entirely for NIC. Which we have obtained a short.
Suppose it is for the NIC, that should have been mentioned over here. Otherwise, how will the bidder get to know?
May I take one provision?
Your document says 10 minutes.
Yes, it is for 10 minutes.
So you have to stick to 10 minutes. You should have mentioned your 5 minutes. They would have gone by 5 minutes. And if you say 10 minutes, 5 minutes, then from the summary you can see that there is difference of more than 5 minutes. In that case, how could the bidding process continue?
There was a time limit.
Where is the time limit? You did not mention.
In the 5 p.m. it was mentioned in the tender document.
But
kindly pass certain interim order, let the NIC come.
To allow the learned advocate representing the respondent numbers 2 and 3 to come ready with further instruction. Relist the same. 11th of February will be all right with you?
In the meantime,
Stop. The respondents are restrained from finalizing the bid.
Kindly indicate the bid number because 151 bids were conducted on the same date.
Where is the number?
Page tender number is at page 23. RFP number is mentioned at serial number.
ঠিক আছে এটা মেনশন করে দেবেন তো
RFP number and date.
RFP number এত ডেটের এত page 23
bid has been finalized. You lost restrain them from issuing.
Not finalizing.
Oh, final to হয়ে আছে accept করার পর.
Has it been accepted?
No. Only the LOI H1 bidder. It is from the appear that the person was
the bidder, but then it has not been accepted.
So your lordship can
not to finalize the bid till 14th of February 2025 or until further order, whichever is earlier.
State is represented, but no say in that.
Yes.
Should I make the NIC party your lordships? Would lordship give us the leave?
If he can come with instruction that it is there was glitches, he will take steps.
No, the glitches one thing, and the 5 point intervening.
5 point, that is NIC's headache. He is not mentioning the NIC rule over here. Then how can that cover? It cannot.
My lord, to indulgence, my lord. Instead of 19th, can it be 21st? 19th, I will be out of station.
Returnable. It is for your benefit that the court was thinking.
Then let it be on 19th, my lord, but I don't know whether.
I do not mind 21st.
I know for my benefit.
All days are good for me. What to do?
So very, my lord, it's a difficult situation for me.
Not even available online?
Yes.
Not even available online?
Then I will do it online.
It's permissible.
Yes.
But it's always a pleasure to hear a person
Yes.
in front of you rather than to look at the screen.
Will come into play.
Yes.
Then
What do you want?
19th, my lord. My lord, I will join online. I take your lordship's leave on that.
11.
Hello, this is my petition.
11.
Yes, my lord. This is my petition, my lord. May I
Yes,
hand up
please.
the affidavit of service? Yes.
Number 1 is refused.
My lord, respondent number 1 has refused hand delivery, my lord.
Sent by post, postal also refused.
Postal also, my lord, is refused, my lord. Lordship will kindly see. Here, my lord, a tender was issued by the
Respondent number 1 has refused.
tendering authority. Yes, my lord.
Union of India has refused.
Yes, my lord. My lord will kindly see the affidavit of service. It was sent by post, my lord. By hand, they had refused. By post, it was sent.
11 Strand Road will certainly
By
accept
postal
it.
authorities also, they have refused, my lord. My lord, the affidavit of service is there, my lord.
With your lordship's leave, my lord.
Nobody from the Union of India over here, the railways.
My lord, the exigency here is, my lord, there was one tender, my lord, issued by the tendering authority for 2 items. For one of these items, I emerge as the L1 bidder. Subsequent to being declared as the L1 bidder, my lord, the tendering authority calls upon me.
But thing is that in the absence of the respondents, I do not want to hear it.
My lord, the difficulty is this tender in which I have emerged as L1 bidder. Thereafter, my lord, I have been called upon to reduce my bid further and I have acquiesced. They have called upon me to extend my bid, validity of my bid till the end of March this year. I have done that. While on the one hand calling upon me to extend the validity of my bid, my lord, what the tendering authority does is going behind my back. They issue a new tender for the same item. And the bid opening date is the 3rd of February, my lord. So, my lord, my petition will become infructuous, my lord, unless some protection is granted to me. That is the difficulty, my lord. I already have emerged as the L1 bidder in the first tender, reduced my price upon them calling upon me to
The
do
new
so.
tender document, please show me.
Yes, my lord. The new tender document, lordship will find. 234, my lord. Lordship, may I show your lordship the first tender document first? That is page 25. Lordship will see the same item.
Closing date is 3rd of February.
3rd February. Your lordship will
Are
kindly
you
have.
also participating in this?
My lord, I have impugned this action, this tender, my lord.
Yes. So you are not
I
participating?
am not interested in participating in this tender.
All right.
Lordship will kindly see. Closing time. This is, my lord, 4th last line in the table, my lord, from the bottom. 3rd February 2050.
What is page 242? Did you file a writ petition earlier also?
No, my lord, I have not.
This is somebody else?
My lord, there is another bidder called RV who has filed a writ petition with regard to the previous tender in respect of another item for which I am not concerned.
All right. Why have you annexed this order at page 42?
My lord, because when I asked the tendering authority why, my lord, despite declaring me as the L1 bidder in respect of the previous tender, no purchase order is issued to me, my lord, they cite this order passed in the previous writ petition, which has nothing to do with this, my lord, the item that I have been selected L1 for. My lord will kindly, my lord, decide the matter, but for the time being, my lord, if some limited protection is not granted, my lord, the petition will become infructuous because, my lord, the bid opening date is the 3rd of February, 2nd of February.
The closing date of the bid is the 3rd of February.
Lordship.
The opening date, is it mentioned?
My lord, yes.
Where do I get that? Bid opening date?
No, opening date is the same. The technical bids will be opened on the same day.
Yes, my technical bids are to be opened on the 3rd of February itself. My lord, the bid publishing date is there, my lord, the tender publishing date, if your lordship will kindly see. That is, my lord, about 8th line in the table. Publishing date, 3rd January 2025, and on the right side of the table, my lord.
No, that's all right. But the closing time is at the top. It's 3rd of February.
Yes, my lord.
Then certainly it cannot be. 3rd will fix it. 3rd is a holiday.
My lord, they are
Nothing can be
entertaining
done.
bids, my lord, but if they open the bid, if at least my lord is inclined to, my lord, hold that, my lord, the new tender will abide by the outcome of my writ petition. That will also suffice, my
They'll
lord.
not open the bids, even if they receive.
My lord, the
bids.
prejudice to me will be complete if they open the bid. That is the difficulty. Because, my lord, I am impugning this bid, so I am not participating. Third party interest will be created, my lord. May I just tell your lordship in brief what is the matter, my lord?
No, without the respondents, I am not in. Just not thinking of entering into the matter on merits. Where is the refusal?
My lord, 3 affidavit of services have been filed, my lord.
Yes.
My lord, one of them will bear the refusal track report, which was published on India Post website today morning, my lord. That they have refused.
Not delivered. 29th. Refused.
My lord, may I take it out for my lord, my lord?
No, I can see this.
My lord, at the top hand, it's written delivery, not taken.
Not delivered, refused.
Yes, my lord.
It is 29th of January and 30th of January.
My lord, in fact, if your lordship sees in the previous tender also, my lord, the order has been passed in the writ petition filed by the other bidder. Order is passed without the railways.
11 Strand Road hardly refuses service. So this is the reason I'm just
My lord,
wondering.
the order passed in respect
They
of the
cannot
previous
get
tender is
somebody
also ex
from
parte.
here.
My lord, so director can come back at 2 p.m. upon service.
My lord, we can try to serve again and come back at 2
At 2
p.m. if your
p.m.
lordship, my lord, permits us.
You better do that.
Please, my lord.
See if you can get hold of somebody from the railways.
My lord. My lord.
In the morning, there were people out here, but now I cannot see anybody.
Lawyer counsel he can serve.
এটা রাখুন তো দুটোর সময় দেবেন।
At 2 p.m.
Yes.
Grateful, madam.
May it please your lordship, my lord.
And for the respondent number 3.
Lord, before I take your lordship the pages, my lord, just a brief facts. Lord, I took a loan from the respondent number 2. Lord, the loan agreement contained an arbitration clause. Arbitration was invoked. An award was passed. Award in Mumbai. Award was put into execution in Kolkata, Alipur Court. Lord, there was in the execution
You
case.
have implemented the Chief Judicial Magistrate as
That's wrongly done. That's wrongly done. My lord will not delete that. Under order 1 rule 10, my lord will allow me to delete that. Now, my lord, what happened is in the execution proceeding, they got an order of attachment of the property. It's a flat. Now, my lord, we appeared in the execution case. We took a point, filed an application under order 21 rule 99. The order of attachment as well as the execution case, all further proceeding stayed by the district judge Alipur. After that, the respondent number 2 assigned the loan to respondent number 6. Lord, he
not respondent 6, 3.
3. Now 3 is appearing. 3, what 3 did, 3 issued a 13-2 notice. After it is stayed, the proceeding, we replied to the 13-2 notice saying that there is a stay operating. You already got an award. The court has stayed your execution. You cannot proceed under SARFAESI. They said we can proceed. They issued 13-4. Without disclosing the pendency of the case and the order of stay, they filed a section 14 and got an order from the CJM. On January 2023, they did not do anything. Again,
And in the meantime, you did not implead Arsil as party.
Yes. Filed an application in the execution case, served on them, and the respondent number 2 appeared. But the order, interim order extended till date. It is extended. In this conspectus, they filed a section 14 without disclosing, got an order. Now that is also in January 23. The CJM can do it. I'm not saying he cannot do it. CJM, after 2 years, again took up the matter and extended the date of delivery of possession. 3rd is the delivery of possession. 3rd or 4th. 3rd. Lord, my point of challenge is to, Lord, as per Transcore, as per Lord India rules, they have a right, Lord. There's a statutory remedy of SARFAESI. There is not a contractual remedy, comes statutory remedy of arbitration. They can choose any of them. They can go with both. But once there is an order award passed that is put into execution, Lord, the prayer in the executing court is you attach the property, sell it and give me the money. Same is in the SARFAESI. You attach, sell, give me the money. Now, when the executing court is in scene of the proceeding, you suffered an order of stay. You then decide that I will, without disclosing that, I will proceed under SARFAESI. You go to the magistrate and get an order.
When was the NPA declared?
Lord, NPA declared, Lord, the 13-2 notice is, Lord, at what dated 14 September 2022, page 201. Lord, NPA must have declared much 1st February 2016. NPA declared. 13-2 notice you will get at Lord, page 201.
You are Arnab Bhattacharya.
Yes. Now,
February 2016, the account was declared as NPA.
thereafter, they may not
20 lakh is due.
thereafter, they may not invoke the arbitration. Not kindly come to the award once. Kindly come to the arbitration award. Not page 113.
There is a due of 43
Lord,
lakhs.
he will get his chance. Page 113 kindly comes. The award.
113.
113. Lord, 113 award dated 20 January 2016. Take page 117. Take page 117.
Yes.
See at the top note, first line, arbitration against the loan agreement dated 30th December 2012. Lord, there is no dispute about this. This is the loan agreement. Now kindly come to the Lord, page 121. The arbitrator declares that they have a right to claim 17 lakhs, then the cost and the interest on the loan agreement. Now, Lord, after this, they put it into execution. Page 167 kindly comes. 167.
Yes.
Lord, I'm very sorry, just take 165 once. That will be easier for your Lordship. My Lord did not go into anything else. That's the tabular statement which we filed under Order 20 and Rule 12. Kindly take the tabular statement. Kindly see the last column. Flat number, recovery of money, then property, appointed receiver, forthwith direct to make the inventory and make a symbolic possession of the said mortgage property lying in Swapnonil apartment, so and so. So this is the scope of the execution. And the prayer in the execution, your Lordship will get at page 173.
Yes.
If my Lord is at 173, just have a look at para 27. Same property, prayer A, you appoint a receiver, inventory, and prayer C at page 174, that you sell the property and by public auction. After MPA, award obtained, award put into execution. Now, this execution case, they got an order of attachment. But kindly come to the order of attachment, page 161. The pages, the certified copy has come like this, so we had to annex it like this. 161. They got an order of attachment. Manas Kali got that? The decree holder DHR has prayed for attachment of the immovable property of the JDR judgment debtor. Peruse considered, in my opinion, prayer should be allowed. Manas Kali got that? Then this has been stayed. 198. We appeared. We filed after a contested hearing. This has been stayed. 198. Both party file Hajira. 198 top. 14th February 2019. Malakali marks this date. The application for stay of the execution filed by judgment debtor and Ira Bhattacharya is moved by their case. Then last paragraph, considering submission of the both parties, I am of the opinion that the execution of the award should not proceed. And this is still not subsisting. We have got the information slip. But after this, what has been done, page 199, the loan has been assigned to respondent number 3. And our application for addition comes at page 213. Yeah, একটা page দেখা- Not 207 kindly comes.
Has the addition been allowed?
My lord?
Has
No.
the addition, it's
Still-
pending.
Still pending, we have served on them, addition not allowed. Just have a look at 207. We replied to 13.2. This is the reply. 207, my lord is at 207. Lord kindly sees, took the second paragraph. In case of, second paragraph, in case of failure to repay, the company has every right to proceed legally under SARFAESI or arbitration both. Hence, we have every right to proceed under the provisions of SARFAESI to recover the due on full final assets, so and so, so and so. That the rest of your contention is without application of mind and without any legal merit. The case in question, that is the execution case, has entirely on different facts and circumstances, hence cannot be applied here. We are an asset reconstruction company registered under SARFAESI as a secured creditor. We have every right to provisions of SARFAESI. Now, after this, what they did, they approached the magistrate. Take 220 once. This has not been disclosed. After filing our order 1 rule 10, we got this order. Take 219 first, we file the petition, then 220, kindly see what the order passed by the executing court. In the miss case that we filed, I think that protection need to be accorded. Not I am reading, learned advocate for the judgment letter submit the decree holder is not appearing in this case for quite some time. An interim period, there has been an attempt from the decree holder to create a third-party interest in the corpus of the arbitral award. After taking the submission of the learned advocate for the judgment letter and on perusal of the materials on record, I think that protection need to be accorded to judgment debtor against the activities of the decree holder. As such, decree holder is directed to restrain himself from creating any third-party interest. Now, apropos to this, kindly take the order passed by the CJM. First order is at page 222. My lord knows under 14, they have to give a 9-point declaration, which includes that you have to, whether the case is pending. Now take page 223, last paragraph. I will not travel with the entire order. 223, last paragraph. Learned advocate for the creditor undertook that there is no stay of any competent court or forum in favor of the borrower in respect of the secured asset. And on this premise, order under section 14 has been passed. And this is not the end of it. Kindly take me note page. This is an order dated 30th January 23, page 228. He passed the order. Then after 2 years, he takes up the matter by a put-up petition. He thinks that he is the executing court under order 21. He is not. My lord, section 14 is an administrative power. It's not an execution. Kindly see what he writes, that I am the executing court. I can do whatever I want. After 2 years, on a put-up, he picks up the matter and extend the order. This is absolutely beyond the scope of 14. Lord, I am not on that also. Lord, the secured creditor had approached. Lord, kindly appreciates one thing. They may rely on the Transcore and India Bulls judgment. But what happened in India Bulls? Initially, there was a section 9 application. Thereafter, SARFAESI was invoked. Here, the situation has gone one step ahead. There is an invocation of arbitration. There is an award. The award is put into execution. Executing court attach my property. Thereafter, they suffered an order of stay. On the
Let me hear.
My lord, kindly comes to their
You are
PRO.
for the
I am for the respondent number 3, the ARC. Page 20, my lord. What they have prayed for before your lordship.
yes.
My lord, the second prayer read or in the nature of certiorari directing the command and commanding the respondent number 1 to certify, transmit the records in connection on such and such. That is the section 14 application pending before the CJM Alipur, my lord. And same be set aside or quash the order.
All right. What are the other prayers?
And my lord, so far arbitration and SARFAESI is concerned in terms of MD frozen, the petition, the respondent number 3 herein has every right to run with the simultaneously both. It is the dictum of the Honorable Apex Court in MD frozen.
In a civil court is protecting their rights, and you'll go and execute the order. Is it done? Is it permissible?
My lord, so far section 14 is concerned, the learned magistrate or the district magistrate is only authorized to verify the original documents in terms of 9 points of section 14. He cannot adjudicate.
Tell me,
my lord,
whether despite a stay order granted in favor of the petitioner, can you proceed with the sale or to dispossess the petitioner to create third party rights? Can you do it? Yes or no?
My lord, so far this stay is concerned. This stay was granted staying the execution proceeding. Staying the execution proceeding. And so far, my lord, taking possession of the property in accordance with law, in my opinion, my lord.
His property is attached.
No, his property is attached so far my execution is concerned. That execution was stayed. But so far my SARFAESI action is concerned, there is no stay. But that stay can
How
only,
can the civil code enter into the SARFAESI issue?
that is why, my lord, executing court cannot go into the SARFAESI issue, my lord. That is the only DRT who can decide that.
Do whatever you feel like with SARFAESI. Do not touch the property. All right.
My lord.
Will that be all right with you?
My lord, in that.
Try to be practical.
My lord, they have their
You are relating yourself to a particular property.
My lord.
There is a civil court order. There was an award in your favor which has been stayed.
My lord, that award has not been stayed.
You have simply stepped inside the shoes of the
My lord, that
decree
award has not
holder.
been stayed. Kindly takes up.
Whatever, there is a some amount of protection given to the petitioner.
So far, my execution is concerned.
What will you do? What else do you want?
My lord, I have my right to execute SARFAESI action in terms
Go
of.
wherever you feel like. Please come.
My lord, can he challenge this order passed under section 14 before this honorable court, my lord?
I am not looking into it. It's as simple as
And
this.
in that case,
He
my lord,
may
they have no prayer, my
He
lord.
may pray whatever he feels like. The court will pass order relying upon the papers that are here.
My lord, can they go beyond whatever they have paid for before your lordship?
The matter
আপনি তো বলেছেন, আমারটা বলতে দিন।
relates to the flat number 2 on the first floor, east facing, bracket east facing, measuring about 892 square feet, within bracket, super built up area, and 1 car parking space, measuring about 98 square feet, on the ground floor of the building. What is the address?
This is at page 220.
Blood address is at page 221, the possession notice.
21.
Secured asset, page 221. Can you take? Flat number 2, first floor, car parking space, building, 94 Bospara Road, municipal premises, 94 Bospara Road, municipal ward number 123 within KMC, district South Chennai Parganas.
এইটা তো কত অবধি বললাম?
98 one car parking space measuring about 98 square feet on the ground floor of the building.
হ্যাঁ, এটা টুকু দেবেন তো। এটা এখান থেকে 221 পাতায় পেয়ে যাবেন। Ground floor of the building, built and constructed. ঠিক আছে? The secured creditor has been restrained. The original secured creditor was restrained by an order.
But two orders are there.
14th of February 2019.
And thereafter page 220.
In money execution number 23 of 2016. From proceeding any further with the disposal of the miscase number 343 of 2018, as the award was passed against a dead person. Stop. The money execution case number 143 of 2016, bracket A, old number 23 of 2016, was stayed till a particular time, till 15th of April 2019, awaiting disposal of the miscase.
No, this has been extended till 6 March. I have given the information slip.
Number 343 of 2018.
It is extended till 6 March. On the right hand side, my lord will get the answer.
The interim order has since been extended till 6th of March 2025.
There is one more order of injunction, page 220.
The learned additional district judge in Miss Case number 343/2018 passed order on 15th of September 2021 restrained the decree holder from creating any third-party interest in the corpus of the arbitral award without the leave of the court. Stop. No order has been placed before this court passed by a competent forum modifying / setting aside or vacating the interim protection granted to the petitioner. Stop paragraph. The respondent number 3, now the original secured creditor has assigned the loan to the respondent number 3. Stop. The respondent number 3 has obtained an order from the learned Chief Judicial Magistrate Alipur
(222).
(222) is the petition possibly.
No, 222 is the order.
Oh.
Miss Case number 217 at the top, my lord. I saw 223 last paragraph. And the ordering portion, my lord will get at 225.
225.
225 is the ordering portion.
अच्छा की बोलना learned.
The respondent number 3 has obtained an order from the learned Chief Judicial Magistrate Alipur
In Miss Case, order on 30th January 2023 in Miss Case number 217 of 2022. By appointing a seal bailiff as court commissioner to take possession of the secured asset. Stop. The order of the court dated 30th of January 2023 was not executed, and video order dated 14th January 2025, the learned Chief Judicial Magistrate Alipur directed execution of the said order dated 30th of January 2023. And date of possession.
That my lord will get at 221, not in the order 221. After this order, they issued a possession notice at 221. 4th February 2025, second paragraph, last line.
When date of possession has been intimated to the petitioner as on or after 4th February 2025. Stop. According to the petitioner, as he is protected by the order passed by the learned additional district judge restraining creation of third-party interest over the subject property, over the secured asset. Accordingly, the learned Chief Judicial Magistrate would not have passed order directing handing over of possession of the same secured asset. Stop. It has been submitted that the order was obtained from the learned magistrate upon total suppression of facts. Stop. It has been contended that parallel proceeding before the civil forum and under the SARFAESI Act cannot continue. Stop. Paragraph. Prayer has been made to restrain the respondent number 3 from proceeding to take possession of the secured asset.
Prayer G, page 22.
Paragraph. Learned advocate representing the respondent number 3 submits that the said authority can always proceed parallelly before 2 different forum for taking possession of the secured asset. Stop. Paragraph. The upon hearing the submission made on behalf of the parties.
May I prefer one indulgence, my lord? The stay was so far I cannot create any third party concern on the property. And so far this order is concerned, this is only for the purpose of taking possession of the secured asset.
How do you take possession?
By action of this order, my lord?
Yes. What will you do? You'll throw them out?
My lord, I cannot transfer that property.
No, what will you do? You will throw them out. And then what will you do?
My lord, if I cannot sell it, I will not sell it.
The property is already attached.
My lord, so far this service action is concerned, the property is still lying under their possession, my lord. So far this stay is concerned, that is, I cannot create any third party.
Parties. The court is of the opinion that as the right of the petitioner has been temporarily protected by the order passed by the learned civil court, accordingly, it will be improper for the respondent number 3 to take possession, to proceed to take possession of the secured asset at this stage. Stop. Paragraph. The parties are relegated to the competent forum to take steps in the matter in accordance with law. Stop. The writ petition stands disposed.
Kindly set aside 221. Kindly set aside page 221. Unless the possession notice goes, Lord,
this is
it has to be gone.
This will go before the criminal jurisdiction. You get it done from there.
No, my lord, he has not passed order under criminal jurisdiction.
Learned tribunal will not be prejudiced by this order, my lord.
Then
everything kindly record that. Otherwise, my lord, learned tribunal will pass order in accordance.
Lord, he has become functus officio as per the court.
The learned tribunal, my lord, in that case.
Which tribunal I will go?
That is your choice.
No, I cannot go to any tribunal. You have to go to the civil court and get the decree executed.
How can I go to the civil court?
You have gone.
They have to challenge this order under section.
It is your execution. It is your execution.
Affidavit of services.
Only 221.
Act 9 লিখে দেবেন যে ওই যে the secured asset is has already been attached by the order passed by the civil court. Is already suffering an order of attachment passed by the learned civil court.
But this possession notice should be set aside.
In this situation, kindly record that the learned tribunal below will not be
recorded that they
prejudiced by
will
this
not
order.
take
With your ladyship's kind leave, my lord, before the list is called on, my lord. But today there is a resolution at 3:30, my lord, as we find, my lord. But I was mentioning with regard to item number 57, my lord had taken it up, my lord. This pertains to that petroleum dealership, my lord, which was being held back by the district magistrate of Burdwan. So, my lord, the oil company submitted that no, the antecedents pertaining to criminal cases pending, my lord, that cannot be a ground. And the report was filed, my lord. So it is just for the order, my lord, which needs to be passed formally, my lord. So, but today I don't think, my lord, the list will reach till item 57, my lord. But may it be taken up, my lord, on the next available date at the top, my lord.
I cannot assure you.
No, my lord, because, my lord, I am told, my lord, that there is a threat, my lord, because, my lord,
Threat
remember,
for what?
I'll tell you, lordship, my lord, the letter of intent was, my lord, based on a timeline. So, my lord, there is a threat, my lord, that might get cancelled. So, but this is something which has been communicated. Otherwise, I would not have come up now and troubled your ladyship, my lord. So, my lord, may it be taken up on 5th. 5th is the next available day, my lord.
Yes.
At 10:30, I'll serve a notice about
Not
Mr. Singh.
10:30. You serve notice 5th, you come. Let me see what can be
Very well,
done.
my lord. My lord, 11:30, any time, my lord.
No time can be fixed. You serve notice. Let me see.
Very well. Very
Well,
well.
I'm
Great.
making a similar prayer for item 49. My lord, I shall serve a notice. Well, I'm just, my lord, I will try to remind your lordships, my lord, on the 5th morning. If your lordship finds it, my lord, convenient, I would request your lordship. My lord,
49, what is there?
my lord, this is, my lord, your lordship might recall that, my lord, there was a clause, my lord, in a tender providing for arbitration in case of a dispute.
All right.
Tender worked out, dispute has arisen. Now, my lord, the tendering authority says, no, we have now since removed the arbitration clause. Now, if your lordship does not hear out the matter now, my lord, then my limitation will set in even for the purpose of a civil suit. I had submitted earlier. It's a short question of law. I think one Supreme Court judgment will cover it, but I have to naturally address your lordship.
Come back, same thing. Come back on
I
the
know.
5th. Let
I
me.
know. I'm just, my lord, mentioning it, just bringing to your lordship's notice. We'll come back. My learned friend has come from Delhi for this, so that's why, my lord, I'm
Oh, is he assisting you or for the other side?
assisting me.
All right. So let us see on Monday. Next working day is Wednesday.
Wednesday. We'll serve a notice and
Yes,
mention. I'll remind your lordship on the morning
Yes.
if your lordship permits.
And your junior can join online. No difficulty with that.
Great.
Is there a 2 p.m. matter?
Well, item number 11, we have, my lord, finally managed to serve the advocate who had appeared for the, my lord, not served. That is a wrong expression. To, my lord, bring the advocate who had, my lord, appeared on the last occasion for the Northern Railways.
My lord, I've just been intimated about a minute or a half ago that
Thing is, the copy was sought to be served upon 11 Strand Road. Why has it been refused? Usually it is not done.
my lord, I am not aware of. Really, I'm not aware
That
of. I've
is-
just
that is
been
the
told
reason.
a minute and a half ago that
He
this
tried
is
to serve even during the lunch recess.
Yes. Nobody is accepting notice, so
Milord,
I was inquiring.
the difficulty is I am not being authorized. Then Milord has, by a special direction, has to put me in the matter.
Did you appear in the earlier matter?
Yes.
The earlier matter I was there.
Then-
Most probably it is regarding on supply and something.
It's the same matter.
Whatever.
I tell you, lordship, it's the same matter.
If you appeared in the matter, then the court can direct you.
SRV Railways.
RV Railways.
RV Railways. Yes. So that I appeared, my lord.
245, the name of
In that case, I can direct you to appear and take instructions.
My lord.
All right.
As a lordship.
But then an interim order, the petitioner is pressing
Lord,
for.
I'm not aware even.
I'll tell you.
I understand.
I
You were not aware.
Word of it.
Yes.
I'll tell you, lordship, my lord, I'll not make a, my lord, very expensive prayer today. My lord, apprehension is that, my lord, the new tender, which is for the same item for which I was the L1, my lord, bidder, and, my lord, thereafter, post negotiations, I'd further revised the price. They had extended, my lord, the bid validity period. My lord, my apprehension is that as soon as I participate in the new tender, my lord, this writ will become infructuous, and my rights as the L1 bidder under the old tender will, my lord, get effaced. So, my lord, I'm naturally apprehensive. For the time being, I understand my learned friend has to take instructions. The bid opening date is on the 3rd of, my lord, February. My lord, I will only, my lord, pray for before your lordship today that if I participate, I can participate in this tender without
prejudice to your rights and
and contentions. And, my lord, let my learned friend take instructions, come
Yes,
back on
yes.
the 5th. My lord, no decision, my lord, will be taken. I know that they will only open the tender, technical bids.
What I could remember is some kinds of clips which are very much necessary for running
The
the
court is
railways.
also not
What I
aware.
could remember, my lord. So no
No,
interest.
no, I do not want to put my learned
The
friend in difficulty.
Court is also not aware what the
Yes.
matter is about. All right. Where is the earlier tender?
My lord, earlier tender, your lordship will find at page 25.
Tenders at 234. New tenders at quantum is different.
My lord, if your lordship will kindly see, my lord, the item details are there at page 25. My lord, kindly see item number 2, my lord, serial number 2. My lord, this is in respect of description, manufacturing supply 10125 curved switches with such and such. Then your lordship will find it pertains to RDSO T 6216. This is a drawing number for fittings in 1 in 12 BG 60 kg turnout. Now this is the equipment. And my lord, here, so far as this is concerned, the total quantity your lordship will find just thereafter under the against the word consignee, 1200 sets for Uttar Pradesh and 65 sets for Delhi. Now, my lord, post reverse auction, well, I was the L1 bidder that your lordship will find for this item, only for this item. I'm not concerned about the rest.
Please come.
Page 196.
The petitioner participated in the tender floated by the Northern Railways, being tender number 77239055 caps RGC. The petitioner claims that he was adjudged as the successful bidder. The agreement, however, has not yet been executed. The authority has come up with a fresh tender, being number 77259001 caps RGC, in respect of the same category of item which is mentioned in the earlier tender. Paragraph. The petitioner submits that the authority ought to have entered into an agreement with the petitioner, but without doing so, has proceeded to float a fresh tender. The petitioner has not yet participated in the fresh tender, and the closing date of the said tender is 3rd of February 2025. Prayer has been made to direct the Northern Railway not to proceed any further with the subsequent tender till the contract is agreement, till the agreement is executed in favor of the petitioner in respect of the earlier tender. Paragraph. The none represents the respondents. Copy of the writ petition which was sought to be served upon the authority as returned unserved with the postal endorsement refused. The court has accordingly directed Mr. What is your name, please?
I'm giving him. I'm with Miss Sanchita Roy Borman in the earlier matter. I'm giving my name.
Namta diye din to. Also, who appeared on behalf of the authorities in the
Page 245, your lordship will get the WPO 413 of 2024.
My lord, I cannot appear myself. My lord, kindly direct me to appear, my lord, because I myself cannot appear. I do not have the authority.
The court is directing you.
My lord.
You are not appearing.
My lord. My lord.
Dujanar naam diye din. Who appeared for the Same respondents. In WPO 413/2024, within bracket RV Rail Products Private Limited and another versus Union of India, service through the Ministry of Railways and others.
My lord, that has subsequently been WPA.
It has been renumbered.
Yes, it has been renumbered as the matter I was dealing with has been
It has been
renumbered as
renumbered
WPA.
as W. I don't know. I don't have.
My lord, that I know about the earlier matter. It has been renumbered as WPA because it was not maintainable in the original site. Because
anyway, you represented the department.
I represented the department. Whether, my lord, in that matter that has been done with, I am not aware of anything, so I do not know. But that matter has been renumbered, has gone into the appellate side, and has been
whatever. Page 245. There is one document annexed.
Yes.
Relying on this order is being passed.
Yes.
Acha. To defend the respondents. It's a continuation of it. To defend the respondents in the instant matter. Stop paragraph. As the court is inclined to hear the respondents prior to passing any order in the matter. Accordingly, the writ petition stands adjourned till 11th of February 2025. Stop. Next. The petitioner is granted leave to participate in the subsequent tender without prejudice to their rights and contentions in respect of their claim in the earlier tender. Stop. Paragraph. Any steps taken in respect of the subsequent tender during this period shall abide by the result of the writ petition.
I'm grateful. My lord, instead of the 11th, could it be the 12th or my lord?
All right, 12th.
I'm grateful. Well, I'm making over a copy to my learned friends here and
yes.
now.
Accept the copy.
My lord, kindly records that as per my lord's direction.
Yes. Why are you so apprehensive?
Refusal
the court is directing you to appear. And only because you appeared in the earlier matter. This is the reason.
I'm grateful, very grateful.
Yes.
Well, I'm appearing for the petitioner, Mr. Bhattacharya, and other.
Matters was stacked and the two matters were appearing. But today, unfortunately, I find that only one writ petition is appearing and other is not.
Well, that will not affect. That will not affect the hearing of this case. But that is simply an application relating to a particular case, relating to irregularities, and my lord, other things. Nothing to the merits of the case. The main application is here, 5368, which is before your lordship. Well, it was hard for many days, and your lordship directed that today by that will go into the merits of the case. Days after days, my lord, they are lingering after the matter. Cannot hear out the matter.
এখানে দুটো মামলা একসাথে অ্যাপিয়ার করছিল তো একটা কোথায় চলে গেল? The file is here, don't worry. Somehow, due to inadvertence, it has not been listed, but the file is here.
The last order dated 29th of my lord November.
My lord, may I?
It is for the petitioner. Let him start.
Will it be my lord's pleasure to hear me on another date, my lord?
Who are you for?
I am the added respondent.
No, my lord, he has not been added. His application has already been dismissed, as your lordship has already observed in an order. He has neither made any restoration application.
Submitting before court.
Nothing. Because he is
Hearing for.
I am petitioner. I am petition appellate. I am assisting him.
So then, if the senior is here, you do not jump inside.
He has given me the debate. That's why.
Lord, I have been added as a respondent. It will be different.
My lord, that is regarding the other writ petition, not this writ petition.
Reflect from the orders, my lord. Your lordship will kindly hear me on another date after he's completed.
Let us see whether to hear you, not
Lord,
to
may I
hear
have-
you. Let the petitioner start at
I
least.
have my lord's leave to leave, my lord. I'll go to courtroom number 30.
My lord, may I please
Which
in a
writ
nutshell?
are you placing now?
My lord.
Which writ petition are you
My lord, that
placing?
is 5368.
Very well.
far as 5368, my lord, your lordship, earlier direction was to file a report, my lord. May I file the report? There are
Please.
4 cases. All are charge sheeted, my lord.
Please give.
After completion of investigation, charge sheet has already been filed, my lord. And present, my lord, trial is on.
Your Lordship,
Malad,
so far,
can I interrupt for a moment? Charge sheet has been filed in 2014. 10 years have gone by. Only in one case, out of 42 witnesses, 2 witnesses have been examined. Next date is 2025. Malad, now Lordship, you will be kind enough to go into the merits of the case, whether those 4 criminal cases are fit case for quashing of the proceeding in view of Bhajanlal case. But that's only my point here.
Yes, please.
may I start with their report, my lord?
Report filed today.
Yes.
You got a copy?
Yes, sir, my lord. They have served. My lord, we have already handed over with your lordship about the. My lord, there are 4 cases filed. No, my lord. Regarding 314, that is a Shakespeare Sharoni case, police station case number 314 dated 19th of August 2013. That is of page. No, page initiation is there, my lord. After the Justice Ghosh's order, it is the report starts. That's very that first page and second paragraph. Where from the report is started.
Where from are you reading?
But the report, they have filed it.
Lordship, before the
Status report given by them.
Status report.
Today they have filed this report as well.
Is it something like this?
Your lordship.
All right.
Well, let's just past 5 pages after that the report starts, I believe. After Justice Ghosh's order. Honorable Justice Titanku Ghosh passed an order. And thereafter the
After Justice Ghosh's orders, I do not have a single page.
well, this is the report. What may I hand it over to you, lordship?
I have already.
The report. All right, I have this. Yes, Derin Tota. Yes, I have it.
No, well, kindly see the paragraph 2.
Yes.
That is first case, police station case, Shakespeare Sharoni police station case number 314, dated 19th of August 2013.
Yes.
Well, let's kindly see the last page of it. That at the present case is under pre-trial stage.
Yes.
Even all the witnesses has not been completed with. And this report has given on 1st of February 2024.
Yes.
Now, my lord, may I draw your lordship's attention to the very next page? That is Shakespeare Sharoni police case number 340 dated.
Already charge sheet filed.
My lord, may I complete? May I complete? Why the state is irritated? It is in between the private respondent and the petitioner. Why state is interfered with it? So my intention is correct. My assumption is correct.
Yes, what is it?
My lord, that is Shakespeare Sharoni police case number 340 dated of 16th September 2013. See the status of it. After commitment of the case, it has been transferred to the learned additional district judge and session judge, 2nd FTC, City Sessions Court. At present, all the accused persons are facing trial. Out of 42 PW witnesses, 2 witnesses has been examined. After lapse of 11 years. And this report is also given on the same day, 1st of February, 1st of December 2024. Now, this case and the next one, the case number 397 dated 11th of November 2013, that is also Shakespeare Sharoni case. Why am I showing I am coming to the writ petition thereafter? This is also dated 11th of November 2013, and the result is the on completion of the investigation, charge sheet under section 120B, 143 and such, IPC was submitted within the stipulated period against 18 accused persons, including the present petitioner. Trial of the case is pending before learned ADJ, FTC, City Session Court. So there is also no case of witness. No witness has been concluded till date. Only filing of the charge sheet. Why am I placing these three? Because all these three cases, my lord, arising out of not from any complaint made by anyone, but from 161 statement made by a particular person and two persons rather, and wherein the petitioner's name was also not been included. That has not been taken up. And out of more than 50 accused person, only this petitioner has been harassed day by day by the police authority, and the other persons are till date absconding. Some of them has taken bail, some of them has not. The petitioner has already taken bail. Now, my lord, may I draw your lordship's attention to the page 3 of my writ petition. Page 7, paragraph 3. My lord, the petitioner is the director of, may I have your lordship, page 7, paragraph 3 of the writ petition, 5368.
You have to stitch up your writ petition.
Okay,
The stitch
lordship.
has
I will-
gone. Page 7, paragraph 3.
Paragraph 3, my lord.
Yes.
The petitioner is the director, and he was entered into an agreement for sale with Messrs. Heartline Estate Private Limited, who was the owner of the premises number 9A Short Street, Calcutta 7,16,000, by way of two registered conveyance deeds, which was duly registered in Mumbai. Now, my lord, may I draw your lordship's attention to paragraph 4. Whereas the then owner, that is Heartline Estate, Messrs. Heartline Estate Private Limited, conveyed the said property to Mr. Sanjay Sureka and Mrs. Swapna Sureka with Messrs. Sriraj Flat Holders Private Limited and Messrs. Recruitment Commercial Private Limited became the confirming parties on that agreement. So the petitioner and his company was nowhere within the agreement, wherever it is fraud, irrelevant, illegal. They were only the confirming party. They were neither the vendor nor the purchaser. Now, my lord, kindly come to the page 5. That since Rotollah Lahata, since deceased, and agreed to vacate the premises, who was a trespasser actually. Premises 9A Short Street, Kolkata, against a total consideration of rupees 3 crores, out of which rupees 75 lakh was paid to him, and balance, and it was settled that balance would be paid on or before 31st of December 2010 at the time of handover of vacant full peaceful possession by the said Ratanlal Lahata. Till then, since Ratanlal Lahata was there, he was not only, he was there. On his behalf, rather, he was lended or whatever the transaction in between them, we don't know. I am coming to later on, who is not a party to these proceedings. Mamta Agarwal, the person who was actually in possession and operating a school from there, which was a private school. Now, my lord, kindly come to page 6, paragraph 6. That Ratanlal Mahata, instead of honoring the commitment, created a deed of conveyance in his favor and filed CS case number commercial suit 41 of 2011 along with GS such and such in Calcutta High Court, wherein by an order dated June 30th of 2011 passed by Honorable Justice Sanjeev Banerjee, dismissed the aforesaid petition of Ratanlal Lahata since deceased with cost of 1000 GM. Now, my lord, I am drawing your lordship's attention to that very judgment of passed by his lordship. That is starting from page 39, annexure P2, and I'm not troubling your lordship to go in total judgment. May I draw your lordship's attention from page 43. The paragraph starts with section 2131. May I read?
Yes.
Section 2131 of the Succession Act uses to word established. It follows that the prohibition thereunder is for a right under a will being conclusively demonstrated in the absence of the will being probated. The provision does not preclude a right under a will being asserted. Upon a plaint being filed, it is a right which is merely asserted. It is only when the decree is in favor of the plaintiff that it can be said that the right canvassed has been established. If section 211 declared the legal character of the executor of the representative of the testator and waste the estate in the executor. It cannot be said that such wasting is suspended and there is no matter of the estate till such time that the will is probated. The wasting taking place under the will upon the death of the testator, subject to the executor accepting the office and the probate only
Perfects the same.
the same. The preliminary challenge of the defendant is devoid of merit. The incidental argument of the third defendant that till such time that the probate is granted, no interlocutory order based on right asserted under a will should be passed is equally fallacious. If the estate is under threat and there is an immediate injunction necessary to protect it, it cannot be said that the executor cannot bring an action to seek an interim order therein till such time that he overcome the myriad challenges that may be placed in the way of his obtaining probate of the will. Now, my lord, kindly come to last paragraph, last line in that page. For the plaintiff to succeed at this interlocutory stage, they require not only to prima facie establish the validity of the transferor of the property in favor of the third plaintiff, but also to overcome the contesting defendants' claim based on 1999 documents. For if Shoilowala had advised herself of a short street property in 1999, there were inclusion thereof in her alleged will of November 29, 2003 would scarcely affected and previous transfer is title thereto. Though the third defendant relies on Section 48 of the Transfer of Property Act 1882, in such regard, the provision would not apply in the strict sense, since that act by definition relates only to the transfer into vivos. Now, the plaintiff suggests that since no copy of the power of attorney that is said to have been executed by Shoilowala in favor of the fourth defendant has been produced on behalf of the contesting defendants, despite the plaintiff's challenge, the 1999 transaction should be disbelieved.
Why are you reading this?
My lord, because I have to show the nature and the character of the plaintiff who was there, who is the Ratunlal Nahata, who has been declared himself as an added respondent in another writ petition, though he is not representing, he is deceased. Another party whose name is Mamta Agarwal, he has filed an
why will the writ court enter into all these things first? Tell me.
My lord, because I have to show that these persons has no right, but they are in hands in gloves with the police. Now I am coming to the documents to my case. I am not placing that order now to your lordships. No, my lord, all are the malafide acts on their part and with the hands in gloves with the police. Because
there means who is this their part?
Ratunlal Nahata, Mamta Agarwal and all. And the police department, obviously. Not only, I mean, I'm not alleging all entire department, but particularly to some persons. I'm showing to your lordship to that. Now, my lord, kindly come to page 72 of my writ petition. Page 72, my lord, it's an application made by the IO before the learned trial judge, CMM court. My lord, may I draw your lordship's attention to the first paragraph, for the investigation, that is the last part. For the investigation in the case has been taken up by ARCTT. I have gone through the case diary, the FIR itself discloses, though there was no FIR, my lord. Only 161 statement was there. Now, my lord, which page you are reading? Page 72. Itself discuss an offense under section 120B, 148, 149, 395, 397 IPC, which was not in that nowhere previously before this date. And 25(1)B, 2T and 2T Arms Act against Parag Mojumdar, particularly this person, my lord. Though there were so many persons in the, which was that crowd was entered in that premises, which was said in 161 statement. I will show to your lordship that. But only particularly this petitioner was named here. And Kaushadi and others. Hence, it is placed before your kind honor that at this stage of law, these sections can be inserted. Now, my lord,
Was any complaint lodged?
no,
FIR
my
was
lord,
not
only
registered?
161 statement.
161 on which? 161 cannot be on air. It
Only
has to
mere
be in
statement, no
connection.
complaint, no formal FIR. That is my case, my lord. No formal FIR, no complaint.
The case that you read out just now,
Hmm.
from the police report.
Yes, your lordship.
So that means a case was registered.
No, my lord.
Shakespeare Sharoni police station cases, they were registered.
My lord, kindly come to page 68 and 69, my lord, of my writ petition.
Yes.
On this basis of this statement, the case was made.
A complaint was lodged.
No, this is not a complaint. Your lordship, kindly see. Page 68.
68.
Statement of Safiq Ahmed.
Statement where?
Page 68.
A statement was given in connection with which proceeding? The police cannot just call somebody.
My lord, that is the case here. That is the astonishing part of this court. Why we have come before this court? Because I will show your lordship in 482 application also. Honorable Justice Ashim Kumar Rai was observed that whatever done by the learned court below is completely wrong. But I am not interfering with that because I want to continue the trial with the same court, and the court will consider the case according to the merit. I'm coming. This is the first statement from which the case was started. This is the only thing. No complaint, no official complaint, no FIR registered, no written complaint, no police diary also. And that is not a part, my lord. I'm just opening the first fold of it. I'll try to show your lordship that even 4 CCTV footage, only 3 CCTV footages was produced before the learned court below, but 1 footage was demolished by the police authority intentionally, which was the front gate CCTV footage camera. Now, my lord, kindly come to that page 68. Your lordship, kindly come to the second paragraph. He was shifted at, my lord, that is the 4th line, last part. He was shifted at the office room of your mind intentionally, schools, that is the Short Street, 9A Short Street, Kolkata 16, for his take leave. Mamta Agarwal and myself were stay at the night of 10th of November 2013 and 11th of November 2013. My lord, now your lordship kindly come to their status report. And kindly mark these 2 dates, 10th of November 2013 and 11th of November 2013. What else? My lord, kindly come to the report regarding police station case number 340. That is the second report. 340 dated 16th of November, 16th of September 2013. And this statement stated that when at the night the crowd were entered, that night was of 10th of 11.
Which page? Which page?
My lord, that is the report.
Filed today. Filed today.
Filed today.
Yes.
Second report, that is in connection with the Shakespeare police, Saroni police case number 340 dated 16th of November. Now, my lord, kindly record the date. That is of 16th of September 2013. In the statement itself, at page 68 of my writ petition, no date of FIR, no date of written complaint, and the statement given by a person is stated that 10th of November 2013 and 11th of November 2013, they were in the same place. On which basis this case was lodged, my lord, if I ask this question to me? What will be the answer? This is the first come thing. This is the first thing from where they have taken out the cognizance, because they have make out the application, your lordship. Now come to the page 72.
Page 70.
72. which I have shown your lordship just a few moments previously, for addition of Arms Act and all, addition of sections. That is dated 16th of November 2013. So, my lord, if we go by the chain, in September, a case was registered without any FIR, without any written complaint. And the statement recorded of the one of the complainant, so-called complainant, on 11th of November 2013. And an application for inclusion of arms section has been forwarded before the learned court, trial court on 16th of November 2013, wherein your lordship kindly see the last handwritten portion. Forwarded with the prayers for adding of the proper section of the laws. It must be written by the learned court below. Now, my lord, kindly turn the page 73. Now, my lord, kindly see the date, 16th of November 2013. On the very same day, kindly see the language, second line, after those sections, since amended under section. Once again, I want to, if I pause here, if I ask this question, since amended, when it was amended, who has amended it? That on that very day, the prayer for amendment was make out before the learned magistrate. On that very day, the petition was amended without any order. I am coming on the next part. Your lordship will find out that. Now, my lord, kindly see up once again on the left-hand side. Forwarded prayer for such and such, for message over the such and such. Now, my lord, kindly see the order passed at page 74. Kindly mark the date of the order, 16th of November 2013. The very same day when the two applications were came out before the London magistrate.
Where is the date? 16th of November, yes.
Now, my lord, kindly see at the top, there are two dates. One is 23rd of December 2013. Prior to that, 7th of December 2013. Both are just crossed by some Pennington and all. I don't know what those dates are and how that can be reflected in the order. This order passed by a magistrate, chief magistrate. My lord, kindly see at the very first part, the prayer allowed. At the very first part of that order. So the amendment has been completed on that day. On that very day, kindly see the last part. It kept to the record and forwarding prayer of IO, prayer for permission to such and such of Parag Mojumdar, interrogate Parag Mojumdar, and is in PC, who is in PC already, till 21st of November 2013. My lord, after producing all of my record, my learned senior friend will produce before your lordship our CAN application, where you have given the entire case record, from where your lordship will just find out when the complaint lodged before the magistrate, when the complaint case made out, whether a complaint case at all made out, when the CD was called for, and now I am coming to your lordship.
From page 74, what you want to point out? Page
On the
74.
My lord, firstly, once the application has been made for
on
amendment,
16th.
on 16, the
Yes.
amendment was not allowed.
Was not
It
allowed.
was only forwarded with the prayer for the appropriate adding of the proper sections.
What
that
is
has
this?
not been reported. That is, there is no order, particular order on that basis. That is an handwritten. We don't know who has written it.
The prayer of the IO is allowed?
Prayer of the IO is allowed.
Seen the FIR along with the connecting papers. Let it be kept in the records. Seen the forwarding prayer of the IO praying for permission to interrogate the accused who is in police custody till such and such.
Fine, my lord.
As
Now,
wanted into the case, prayer of the IO is allowed.
both the petition allowed on the same day
Yes.
by a same order.
Yes.
Now, my lord, kindly see the entire case record, including the CD, was updated on that day. Now, my lord, may I draw your lordship's attention to another thing of their document. It's not my document. Ota kothay ache oi CD update koro. Impersonation. Now, my lord, before that, my lord, kindly come at page number 75. This was the revision application filed, criminal revision filed by the petitioner before this honorable court. What I have just addressed to your lordship, that Honorable Justice Rai, as he was then, has passed an order. May I draw your lordship's on attention to page 76 of that order. Last paragraph, it is, my lord, ninth line, the sentence start with "it goes."
Yes.
Of the last paragraph. It goes without saying all judiciary's orders must be backed by justifiable materials, and thus it is incumbent upon the court before making any order to look into the materials on which the prayer of a party is made to ascertain efficacy of such prayer. Therefore, I have no doubt that the court below has not acted in accordance with law. I have full confidence on the learned magistrate that in future he will not repeat this kind of mistake while passing a judicial order. The next point raised from the side of the petitioner, that the material on which the investigating agency relied on was not sufficient for adding more grievous penal offences in this case. Thus now, question left for the consideration of this court whether there was at all any foundation for adding more graver offense in the case. However, upon perusal of the first information report, I find there was specific allegation that the miscreants, who were 50-60 in number, being heavily armed, illegally trespassers into the school premises. My lord, kindly mark it. In that premises, there was supposed not to be any school because Ratanlal Nahata was a trespasser. He was in possession. The school was run by Mamta Agarwal, who was no one else, who was only one of the, what I could say, representative of Ratanlal Nahata, from whom Ratanlal Nahata took money. And this is by which way she was given the authority to continue running a school, which I have already argued before your lordship. Now, my lord, and then caused grievous hurt to the informant and others. And at that point of time, firearms looted away valuable articles, including cash money. Undoubtedly, those allegations on the face of it makes out a case of offense, for addition of which the second investigating officer approached the court, and there was nothing wrong. In fact, if the court below, after addressing it on those materials relied upon by investigating officer, made such order, there would not have been any scope to interfere with the same. Be that as it may, when I find that the prayer of the investigating officer was fully justified on the face of the material, more particularly from the allegations made in the FIR itself, even though the order impugned suffers from some infirmities, still I am the opinion that it would be a futile exercise of power or interference with the incline to upset the order impugned. Now, my lord, I am not proceeding with further. Now I am drawing your lordship's attention to page number 108 of my petition.
Page 10?
108, my lord.
Yes, 108.
My lord, kindly see the date is 15th of November 2013. Time is 1:49 p.m. And it is prior to the day of the application made out by the IO before the learned magistrate. It was made on 16th of November. Then, my lord, kindly see, it was sent from ACARS DD Calcutta Police Government.in. ACDRS is sending a mail from that source. But, my lord, kindly see from whom the mail was delivered or mail was sent. From Joint Commissioner of Crime. Case was under the Shakespeare Shorey Police Station. And to DCSD. And enter this Joint CP Crime Anti-Rowdy Department. And Shakespeare, she is sending to DCSDW Shakespeare Shorey Police Station, reference Shakespeare Shorey case number such and such. The investigation of the above noted case has been taken over by ARSDD, please arrange to send the up-to-date case diary along with exhibits, if any, immediately for further course of action or execution. End of the message. Now this is Telemax has gone. Now may I kindly come to the last part of this. Please arrange and send the CD and prepare up-to-date CD and submit it. So from only on that day, this CD should have been submitted before the Joint CP Crime Anti-Rowdy. If I take this is truth to this face of the record. So that from on that day also, the case diary was not up to date. How that case diary, after perusing that case diary, the learned magistrate, without giving any reasoning, on 16th of November, very next day, has added some amendment, added some sections with the gravier crimes. And on the
But
same,
then that is not before this court now. That has already been considered
no,
the earlier.
I'm not placing your lordship to consider on that day. I'm just placing the chain of circumstances by which I'm coming to your lordship, because what we are praying for the quashing of the entire trial, because it is completely. May I humbly submit to your lordship with the permission of your lordship's court? It is completely engineered. Not only engineered, it is motivatedly engineered to harass a particular person only to occupy a valuable property with the intention. And now, my lord, I have not that document, but I can remember on the very next day when the occurrence was happened, the very next day, Anandabajar Putrika was published.
Please restrict your submission to the documents which are already on record.
My lord.
Sir, my learned friend is only showing the malafide and the illegality in which the petitioner was engineered to have been implicated in the present case. Now, my lord, I will go into the merits of the case, wherein my lord has directed me, my lord, to put an application, my lord, attaching or annexing all the documents of the FIR and the accompanying documents, so that my lord can assess that whether there has been a
irregularity
case or not, a primary case has been made out or not. But I shall argue on that. My learned friend is showing the malafide, illegalities and irregularities. Now, my learned can point out to my learned friend that those are malafide, illegalities and irregularities, which can be cured by 465 or 462 of the Code of Criminal Procedure. You go to the trial court and agitate all the points. But my learned friend is showing the malafide, and there, after finishing of my learned friend, I shall go into the merits of the case.
No, my lord, kindly come to the very next page. That is page 109. That is also 15th November. That is also 15th November, my lord. It is also from the same source, Joint CP Crime Anti-Rowdy to the Shakespeare Sharoni. The investigation of above noted case has been taken over by such and such. Same thing, my lord. And kindly note the last portion, which is handwritten portion on page 109. The date 16/11, 16th of November, 2013. Last portion. Please arrange the case diaries, prepare up-to-date case diary, and send it. So, my lord, 16th of November 2013, the case diary was not sent. The case diary was not up to date. It is evident from the face of record. So on which basis this entire allegations made against the petitioners, and he has been, I could say, harassed by holding himself within the police custody by virtue of the order of the magistrate court, learned magistrate, without up-to-date order, without up-to-date case diary. That is the first question, and that is the first malice, and that is the first malafide according to me. Now, my lord, we have no trace of these records prior to we went before the Supreme Court with an appeal. Now, my lord, kindly see and kindly come to page 114, annexure P16 of my writ petition. Kalpana Mujumdar, the wife of the petitioner, he made an appeal before the Supreme Court. This is a civil appeal, my lord. I am only placing your lordship that it was regarding all the cases. There were so many cases pending regarding all the cases. Now, my lord, kindly come to page 3, para 3. When the matter came up before this court, after noticing that there is an element of settlement, we sought the assistance of Mr. Such and such, learned counsel, and also trained mediator. We are informed that the learned mediator has put it more than 35 hours in the mediation and such. My lord, kindly avoid that paragraph. It was regarding to show only the settlement. Now, my lord, kindly come to the paragraph 4. In view of the deed of settlement dated 16th of July 2018, referred to above, we are of the view that for securing the ends of justice, the criminal cases involving them should also be closed. Accordingly, Lake PS number such and such, such and such, and such and such, such and such are quashed. In terms of the deed of settlement dated 16th of July, we direct the district sub-register Alipur, West Bengal, to register the transfer of the suit premises in favor of the appellant, that is Mr. Mrinal Kanti Mojumdar, Mrs. Kalpana Mujumdar, Mrs. Bani Shaha, and Mr. Ustam Shaha. Since the parties have been in litigation, we direct the register concerned to levy only the stamp duty such and such. Now, my lord, kindly come to page para 6. The third prayer in this application for direction read as follows. The deed of conveyance dated such and such, confirmed in 2008, entered into between late Mongobindo Shaw, Srimati Brindarani Shaw, such and such, Recruitment commercials on the other part as a purchaser and registered before the Register of Assurance Calcutta shall be declared cancelled. The declaration as prayed for is granted. We direct the parties to abide by the terms and conditions of the deed of settlement dated 16th of July 2018. The appeal is accordingly disposed of. Though the learned mediator such and such, now paragraph 11, we record our application for the efforts taken by the learned mediator such and such, and for the cooperation extended by the parties and the council for putting of the end almost 2 decades old litigation between the parties, and in particular Mr. Joydeep Gupta, learned senior counsel, for facilitating the settlement. So, my lord, all the pending applications was disposed of by this order. But, my lord, what has happened after that, most astonishingly, state prefers an application for modification in that matter, which starts from page 119. At that time also the petitioner was in jail because his wife was represented before the court. And when the state has made out this application, then also petitioner was in jail. My lord, kindly come to page 119. The order, paragraph 1, the application filed by the state is taken on record. It is prayed for the application or applicants must be that the following cases have nothing to do with the settlement of dispute in issue. Therefore, the following cases appearing in paragraph 4 of the judgment dated 17th of July 2018 are deleted. My lord, when at the time of I'm placing those cases, those are all the numbers I have placed before your lordship. But before that, I most humbly submit to your lordship, the parties involved with a dispute more than 2 decades, they have settled an issue by virtue of the direction given by the Honorable Supreme Court by appointing a trained mediator. Every issue has been settled in between the parties. My first question upon this appeal, what prompted the state to take an action regarding this for modification of that order? Now, my lord, kindly come to paragraph 1, the last part, Shakespeare Shorny PS case number 314-213, number 340-2013, case number 397-2013, and this thing. Though, my lord, these 3 cases are most astonishingly connected with the same portion, 9A Short Street, where the owners were agreed to settle the dispute.
Were you heard before the Honorable Supreme Court?
My lord, kindly come. Paragraph 2. Consequently, all the above 3 cases are directed to be proceed with in accordance with law, since they are not otherwise settled. The order passed by the trial court discharging the accused in the above 3 cases will stand recalled. The cases will proceed from the stage they were pending before the trial court at the relevant time. The trial court is directed to summon forthwith those who have been discharged and proceeded with the matter in accordance with law. Needless to say that accused will have to seek regular bail, and when they are summoned by the trial court, it will be open to the trial court such and such. Now, my lord, kindly see the date. October 1st, 2018, that is at page 121, the direction given by the Supreme Court. Once again, the cases were started. Now, my lord, we are standing today on 31st of January, 2025. From 18 to 2025, amongst those 3 cases, nothing has happened other than one case, only 2 witnesses. If out of 42 witnesses, only 2 witnesses has been completed. Now, second thing, in the all 3 cases, the accused were more than 70 or 80. Only these persons against whom the case is continuing, other are till date are showing absconding. Now, my lord, if I stop here, if I pause here, if I ask this question to me, is it not intentional on the part of the state to drag these proceedings only to hamper the entire commercial position and the commercial standard and standard of living of my client, that is the petitioner? Intentionally, because they know when the trial will come out, when the CCTV footages will come out and that will be exhibited, that will be put on witness and that will be recorded as a witness, the entire hands in gloves. I'm not telling the name, but I'm just indicating one position. One of the senior officials of the South or Central, who was lived in Park Street, whose name starts with B, entire face and entire work of him will be come out before this before the magistrate court, and they have to suffer from the injustice. No matter they are intentionally try to avoid the entire proceedings initiated in the writ petition. Why we are here before? If we get the proper relief and proper examination and proper trial before the learned court below, learned magistrate court, since 2018 even, we have crossed more than 7 and 8 years. My entire business ruined, my entire prestige ruined, my social prestige, my family prestige, everything ruined by them.
No,
They are hands in gloves with the respondent, private respondent.
Done now.
Well, the trial should be quashed. There is nothing in the matter. If within 11 years or 12 years, nothing has been investigated by them.
Are you aware as to how many criminal cases are pending for 10, 20, 30 years?
We are relying on some cases. That is why I am now inviting my learned friend to place the matters now.
I shall go into the merits of the case. The next today is 3:30 today.
Yes.
One by one, I shall go into the merits of the case. I have annexed all the documents. I shall satisfy your lordships that no case has been made out. Unnecessary, my lord, I am harassed.
Only one thing, my lord, my submission is, my most respectful submission is that I was nowhere in this matter. I was made a confirming party to a registered sale deed. Why the proceedings has been initiated against me? Nothing has been produced, nothing recorded, no name has been taken by anyone till the proceeding is continuing against me without going to the proper accused.
You are out on bail right now.
Yes.
Yeah.
So you can do your business. Anybody standing in your way of doing
My lord,
your
I am in
business?
enlarged in bail,
Yes.
but I have to.
Your personal liberties are not curtailed.
My lord, I already have lost my more than 12 years.
No, what
My
you
lord,
have lost, the court cannot bring it back.
My lord, your lordship on the last occasion directed my learned friend for the appearing for the state, my lord, to call for all the records of the case. My lord, on the next day, my lord, kindly, my lord, direct them to produce all the case records, so that, my lord, I can argue one by one. And my lord,
These records are with the trial court. Trial is on.
why? Case diary, case diary.
Because of the matter went up to Supreme Court. They have argued before the Supreme Court some forged documents and finally Supreme Court has quashed the entire thing and remitted it back to the trial court for trial. And that the delay has happened.
This cannot be the cause. According to the police regulation of Bengal.
They themselves have cited the Supreme
Just a minute, brother. According
that
to
is not-
according to police regulation of Bengal, 3 sets of case diary are to be kept, are to be prepared. One case diary must be withheld by the investigating agency. Let them produce all the case diaries. I shall argue one by one, and I shall try to satisfy your lordship. If I cannot satisfy your lordship, throw me out of the court.
Wait. Page 68 has been placed before this court. Page 68.
There are 2 matters. In another matter, man, so out of the same
Listen,
thing,
listen.
I have filed my lord, opposition In the very opposition, I have stated everything.
You tell me page 68 has been placed before this court,
Yes, yes, yes.
right? This is the 161 statement of one Shafiq Ahmed.
That's why in this matter, there is no affidavit in opposition in this matter. There are two matters, one of 2021 and another is 2023, filed by the same person. In the 2023 matter, court has directed me to file affidavit that is before your lordship. In that very affidavit, I have stated everything. Your lordship allow me to file affidavit in this matter also. I shall
Will you please tell me if it is the same matter, then you must be knowing page 68. Was there a complaint lodged?
Yes, it's complaint lodged. My lord, that's why affidavit is needed.
I have annexed all the documents.
In this matter, Mr. Amrit Banerjee was, my lord, he was leading me, my lord. At present, my lord, another, my lord, senior state lawyer should represent the court before leading me, my lord. So
You can lead yourself. You do not require somebody else to lead you.
My lord, I have annexed all the 161
Page
statements.
68, there is a statement. In connection with which proceeding was this statement recorded?
my lord, I have to take instruction for that. Take instruction for that. All of a sudden, my management has submitted all this thing. Or your lordship kindly direct.
All these papers are there in the writ petition for so many years. And you need to take instruction now. Oh, is this how you are defending the state?
I have to take instruction. Particularly for page number 68, I have to take instruction.
All the other pages you have instruction, and the only page the court requires an information, you do not have instruction.
Dealing with all the pages, all the points taken in the writ application. That opportunity should be given to me,
My lord,
From 2021 till 2025, you did not get opportunity to file opposition.
No, but there is no order for filing opposition.
Do you think that without an order you cannot come up with an opposition? If this is your idea, then you are wrong. If you are not ready with an opposition, you should have been ready with the instructions.
I have filed my instructions there. Your lordship, last occasion, your lordship asked me to submit before the court what is the present position of the case. So that's why I have taken instruction that the present position is this. One of the charge sheet has been filed and the trial is on in the 4 cases.
No.
Three of the Shakespeare Sorony cases and one of the Anandapur PS cases. And your lordship kindly allow me 2 weeks time to file affidavit, but I said 5 months.
Every time they are taking time. Every time they are taking time. At least on 4, 5 occasions the matter has been heard. Then there has been a stay of all further proceedings. And my lord will kindly direct for the case diaries, which are kept to the investigating officer. And my lord will kindly.
The case diary, they are trying to further delay the proceedings.
Why?
Trial which is on. This is their only motive.
I want the matter to be heard by next week. I want to finish the matter next week. There's no time.
Within a certain specific time, trial should be completed.
Why the matter? Why the case diary?
SP officer has a copy.
My lord will kindly call for the case diary and my lord kindly keep it with your lordship said God. And
it's a very checkered history of the petitioners, my lord.
You know the entire history and you do not know how the this proceeding initiated. You know everything, isn't it? What type of submission is this?
Then your lordship kindly allow me to place the that writ application is not there.
All the papers are here.
My lord, may I place the affidavit in opposition? Then
Whatever you like, you can place it. Nobody is stopping you from placing any document.
Lordship kindly take up the matter, my lord. That is, my lord, writ petition number 18030 of 2023.
That is not tagged, my lord. That is unfortunately it's not tagged.
Yes, that it is here. Well, who has done intentionally? What has been done intentionally?
Matters are continuing, my lord.
Both the matters are here, I told you.
I'm sorry, my lord. Extremely sorry, my lord. May I please?
Please do not try to cast aspersions on the court.
My lord, I'm extremely sorry. May I place the, my lord, affidavit?
What is your answer to page 68 that has been placed? If you can find the answer in your opposition, Please place it.
Your Lordship, kindly come to page 20.
opposition.
Oh.
That
That FIR has been filed, my lord.
That is FIR. That is not on
340 on 16th of September 2023, 2013.
under section 140.
Under section 147, 148, 149, 179, 448, 427, 506,
formal FIR.
120B of the IPC. And my lord, the complainant is my lord,
Added section.
and that added section,
My lord, no affidavit has been given to us. No copy of the affidavits. That has not been served by them.
this is, I have served it, received
To
by,
whom? Mamta Agarwal?
no, I think.
Must be, because she has also given an affidavit over there.
Your signature.
My signature?
No, somebody's signature they have received from my clerk.
From Miki Upadhyay.
If it is not served, then I shall serve, madam.
Somebody is pressing to get the matter heard. It's pending from 2021 and you take it very casually. If it is not served, I'll serve it. What do you think? The parties are here for fun?
I find somebody has received.
My lord, according to my instruction, we have not received any copy.
The affidavit in opposition of the state is already on record in 18030.
But my lord, we have not received it.
You have not received it?
No, my lord.
And in course of the day, I shall serve.
Please come.
Regarding 18030 of 2023.
Yes,
This
that
is
is
not regarding, my lord, the earlier one. This one is hearing. Your lordship is hearing now. There are two writ petitions. This is the second one.
My lord, may I permit to submit, my lord? There are two crans pending before this honorable court. One is cran 6 and 7. One is cran 6 and 1-7. Or cran 6-7 relates to
In connection with which writ petition?
WPA 5368. Lordship.
Yes.
They are in which the applicants, when this matter was restored, it was dismissed for default, your lordship. When the matter was restored, my cran was not restored, your lordship. So I cran 2 was not restored. So subsequently, I preferred this cran to get that cran number 2 restored, your lordship, for additional party. Safiq Ahmad.
Well, I believe your lordship has already heard and your lordship has passed an order that is for restoration.
Heard.
Well, this petition, he is representing the same person.
Because
Your lordship, kindly go through the order of your lordships.
The petitioner was referring Shafiq and I'm representing Shafiq, your lordship.
Shafiq is not the matter, not a party.
To answer all the queries of this court if I'm added as a party, your lordship.
Well, that is the addition of party application, nowhere related to standing.
When the matter was dismissed for default,
he's not a party.
Your lordship, when the matter was dismissed for default, the original application writ was restored. But the cran.
Yes, I have followed. Your cran was the CAN application that you filed for addition was not restored.
So I want my cran to be restored, your lordship. So can be added as a party.
But after this years,
restoration doesn't mean that you automatically get yourself added.
No, your lordship.
The petitioner will certainly oppose your addition.
Absolutely, your lordship. For such reason, I have filed my cran application.
Where is the application for restoration?
It's in the record, your lordship. Cran number 7.
CAN number 7.
That is also not served up on us, my lord. Not served up on the petition. And I have the preliminary objection regarding the maintainability of this CAN application on the point of limitation.
CAN 7.
6 and 7. Both.
My lord, CAN maybe permitted to say. Now, CAN 5 has been filed by me. One of the accused in Shakespeare Sharoni PS case number 397. That is for one Partho Chatterjee, who is an advocate, my lord, who was conducting all the cases, who was looking after all the properties of this person, legal matters. He has also been entangled And my lord, if your lordship goes through the entire 161 statements of section of the case of 397, my lord would find that there is not a single word has been, my lord, spelled out or whispered in the 161 statements against this advocate, my lord. Being an advocate, my lord, where our duty is to, my lord, safeguard our clients, I have been made an accused.
Can 7 is for restoration.
Well, that has not been solved till today.
Not served? Why serve? When
Which
did you
serve-
file? Filed it on
December. 3rd
5th
December.
5th of December it was filed, 3rd it was affirmed. 5th of
My lord,
December.
let them serve here and now, my lord.
Serve copies, let them go through it, what is there?
And but my lord, kindly record that my preliminary objection regarding the maintainability of this petition on the point
Without
of
going
limitation.
through the petition, how are you raising this? Let him serve.
On the
go
point of limitation, my lord. Because I know when the restoration
Next-
order was.
Next day I'll serve my
Next day.
brother. I'll serve you.
Please come.
আজকেই দিয়ে দিন না এখানেই দিয়ে দিন
আমি copy করে আপনার দিয়ে দিচ্ছি, sir.
My lord, kindly direct them to
Submission
give us by next week.
made by the learned advocate for the petitioner in WPA 5368 of 2021. An application for restoration of Can 2 of 2022 filed in connection with the writ petition has been filed by the applicant seeking to be added as party in the instant writ proceeding. Stuff. Let copy of the application be served upon the learned advocate representing the petitioner. আচ্ছা দুটো can হবে. Can 6 and can 7.
Can 6 and 7.
For restoration of can 1 and 2.
Yes, sir.
Can 6 হচ্ছে can 1 এর জন্য, can 7 হচ্ছে can 2 এর জন্য।
অনেক ক্যান সার্ভিস হয়ে যেত, সবাইকে হয়ে যেত।
1 আর 2
ক্যান্সেল হয়ে গেছে, অ্যালাউ হয়ে গেছে, ও ক্যান্সেল হয়ে গেছে।
let copy be served বললাম তো forthwith stuff. It will be open for the petitioner to file objection to the application seeking restoration of the connecting applications. How soon?
My lord, the day they will give us by 7 days, we will give the opposition.
We'll serve in the course of a day.
Today you can serve?
Yes.
Yeah, in the course of the day করে দিন।
In course of
Or kindly 5th we'll serve with the 5th.
You can forward soft copies also so that they can at least go through it and then you serve the hard
Let it
copies.
be till 5th.
আচ্ছা ঠিক আছে 5 তারিখ করে দিন। 5th আজকে বলেছি in the course of the day যেটা বললাম সেটাকে 5 তারিখ করে দিন 5th of February. It will be open for the petitioner to file objection to the same prior to the adjourned date. List on the 14th. Friday fortnight it is being kept.
Let the matter remain in its position.
Yes, it's a signed matter. It will not go anywhere. It will be here. আর একটা জিনিস, it will be open for the state respondents to file opposition to the writ petition being WPA 5368 of 2021 by 12th of February 2025.
Reply to that, my lord.
Direction.
Come back on the 14th if required.
My lord, only one thing may I pray to your lordship that the opposition should come out with the case IDs,
Reply.
which is with them.
Reply to the opposition.
Copy of the case IDs.
Reply to the opposition may be filed by the petitioner prior to the adjourned date. List on the 14th. দুটো মামলা যেন লিস্টে দেয়, তা না হলেই কিন্তু বলবে যে একটা মামলা ইচ্ছে করে লিস্টে দেওয়া হয়নি।
মানে any direction with respect to my lord can 5.
আর একটা জিনিস, report filed by the state respondents be retained with the records. রিপোর্টের ডেসক্রিপশনটা দিয়ে দেবেন তো। একটা হচ্ছে signed by the officer in charge, Anandapur Police Station on 12th December 2024. আর একটা হচ্ছে যতগুলো আছে সবগুলো আলাদা আলাদা করে দিয়ে দেবেন।
Any direction with respect to can 5, my lord? Wherein, my lord, I have filed an application for adding myself as a party respondent for, my lord, supporting the cause of the petitioner, my lord.
Is the petitioner opposing?
No, my lord.
Then I can add.
He was my advocate for, that is why he was entangled with them.
Can 5 has been filed. Seeking addition of party in WPA 5368 of 2021.
Yes, ma'am.
Stuff. The applicant is the advocate who was conducting or dealing with the matter.
Dealing with the matters of the, my lord, petition.
The matters of the petitioner. Stuff. He alleges that he has been illegally and arbitrarily impleaded in the criminal case.
Shakespeare Shorney PS case number 397 of 2013.
Being Shakespeare Shoroni PS case number 397 dated 11th November 2013 under sections 120B/143/149/458/459 IPC. ঠিক আছে? The petitioner does not oppose the said application. Stuff. Accordingly, the application for addition of party stands allowed. Stuff. The applicant be added as respondent number. দেখে নেবেন কতগুলো আছে তারপরে। ঠিক আছে? In the writ petition. Stuff. Let a copy of the writ petition be formally served upon the learned advocate representing the applicant forthwith. ওনাকে রিট পিটিশনের কপিটা দিন, ওটা স্টিচ করে দেবে। 5368. Tell your clerk to stitch this.
Before your lordship rises,
এইটাকে রাখুন। এটাকে এর সাথে রাখুন।
नंबर दे दीजिए।
हाँ 5368
नंबर दे दीजिए, हम दे देंगे। One kind indulgence before your lordship rises, my lord. This is in respect of the exotic bird matters, my lord.
That has been put up in the server?
Yes, it has been put up in
Check
the server, my lord. Half an hour back, my lord, I've gone through the order. My lord, more or less it suffices our purpose, my lord. My lord, my items are item number 19 to 25 today, my lord, in the adjourn motion. My lord, 19 to 25. My lord, lordship was pleased to, my lord, keep all the matters at adjourn motion.
Right, 19 to 25.
Only apprehension, my lord, is there that, my lord, my client has already been detained once in custody. So if there
is your respondent here?
No, they are not here, my lord. That's the difficulty.
You should have got hold of them.
My lord, I have served upon Miss Pandey, my lord. Then your lordship can do one thing, my lord. Lordship he also wants to make some submission. Perhaps some correction is required in one part of the order, to the extent that, my lord, some points are to be kept open.
Kept open.
Kept open, my lord.
That
Single line.
Show me that order once.
And I ask for this addition only in one of the matters. On one of the two matters, your ladyship has been pleased to dispose of.
This one?
Yes.
This has been disposed?
Yes.
What you want? What is the change that you want to make?
Not a change, an addition. But
addition?
Addition is that all points which were agitated in the writ petition and not decided may be
kept open.
Kept open. So that's all.
So that
right.
Because in the appellate stage also, my lord,
yes, that will be, that line can be inserted, no difficulty. And had you got Miss Pandey, I could have passed
if
order.
your ladyship can keep it on.
Lord, she will keep it on, my lord.
It is there in the list, it will remain, but I could have disposed it of here and now.
Then your
Had
lordship,
somebody been there.
yes, my lord, then your lordship will do one thing, my lord, we'll keep it on Thursday. Because on Wednesday, my lord, we shall officially inform Miss Pandey and the other state advocates.
Miss Pandey must be available over the phone.
But I do not have a number, my lord. Kindly keep
Collect
it on
it.
Thursday.
Her number is available with many. Collect it.
Today, my lord, your lordship would rise. That is why.
What can be done? It is your
Lordship
resolution.
keeps it, my lord, as
It is your resolution.
yes, my lord. I take it on myself, my lord. I take it on myself. Because, my lord, the order came in very late. So, my lord, until and unless the order was there, my lord, I could not, my lord, even move ahead. So if your lordship keeps it on Thursday, it has to be mentioned at the top of the list because
It is there. Bring Miss Pandey. I'll pass orders. Bring it.
Very well.
the
Right?
only
It's there
difficulty
in
is
the list.
well, the only difficulty is that if it is coming under the heading of adjourned motion, well, this
Don't bother about the heading. You bring your other side. The order is here. The court will try to see that you are not inconvenienced in any manner. Right?
My lord, in the next matter, item
Grateful, your
15,
ladyship.
16, 17. My lord, I am appearing for the Madrasa Commission.
But I am for the petition in item 15.
Now, my lord, last night I had a conference. It went on for 3 hours. Quite a complex subject for last 10 years. Now, in the first matter, item 15, my lord, an affidavit in opposition is yet to be my lord, used by us. So may I only seek you before your lordships so that we can get some time to use an oppositions? Because what I felt, my lord, prima facie, man, if I can very candidly.
But I am for the petition.
What is your prayer?
For the petitioner in no, 16. Our prayer is, my lord, by violating the order of the Honorable Division Bench, my lord, the West Bengal Madrasa Service Commission is conducting the selection with regard to first SLST 2010, my lord, non-teaching staff, group D staff, my lord. That has been
By violating the order of the division.
Honorable
bench.
Division Bench.
My lord,
All
I
right.
just indicate.
Yes, my lord, there was a direction by my lord to file affidavit on 5th November 2024. And
not filed.
No. And the matter is ready. Last order passed by my lord that it is ready for hearing, and today is fixed for hearing, my lord.
All right.
They have not,
My
my
lord,
lord,
my lord, so far as the hearing part, I have I have tried to gather all the informations. Whatever informations which are favorable and also the informations which apparently I find may not be favorable to me. What I have found is, my lord, there is a two sides of the matter. There are 3-4 matters. Now, in one sets of students, candidates, they want that they should also be included. Now, there is other sets of, my lord, candidates. They want no, the entire competition should be within us. Now, my lord, either way, there are reasons and counter reasons. All I'm seeking before your lordship is this. Most likely, I would be able to take a very neutral stand in the matter, which would be in accordance with law. But I have to place all the aspects of it. What my learned friend is saying regarding the alleged violation of the Honorable Division Bench's order, now that touches upon this merit of the matter itself. Now, what I am seeking before your lordship is that there is an order so that I can file an affidavit in oppositions. There is one opposition I have filed in one of the identical matters. Now, in this matter, I have not yet used any affidavit. And from my last,
can that opposition be treated as
what
an opposition?
What I have found is what my independent understanding is that the commission was required to be more clear and there should have been more clarity. That was my feeling. So therefore, today, by virtue of your lordship's order, I might be able to utilize so that all facts would be before your lordships. Because my lord, one point will come when I will open up my all cards. Because there are some messed up things has happened, no doubt.
Yes.
So I will open up on that and I will also suggest what could be the possible two aspects of it and what may be the justice. That would be suggestions appearing for this neutral body. Now, so far as today's my seeking, that is limited to using an affidavit in oppositions. And so far as an apprehension part, nothing is happening so that he would be apprehended.
There is an interim order in
yes,
your
my lord.
favor.
Yes, already
By the
protected.
coordinate bench that has been extended till end of April by the coordinate bench, my lord. And my lord, they have also taken out an application that till the matter is some writ petition have been filed challenging the order of the, my lord, a committee was formed regarding by presiding over a honorable former judge of this court regarding, my lord, with regard to the considering the approval and salaries of the existing, my lord, the teachers who are serving in the madrasas, my lord. They according to them 42 writ petitions are pending, and they have taken out an application before this honorable court that until the decision is taken by the honorable Supreme Court, they are in not position to publish the panel or complete the selection process.
So you are protected.
Yes, he is protected.
No,
he is protected.
we are not protected. Our service, we are the candidates, my lord. We had appeared in respect of, my lord, 2011, my lord, 24,000 category, my lord.
Right.
Our claim is that the additional candidates, that 73,000 candidates have been added, my lord, by violating the order of the honorable division bench.
But then, even if anybody is added, they cannot proceed with the appointment or selection or anything.
We are not proceeding.
But they have.
It is the status quo position. What was there in 11, in 25, it is the same thing.
No, my lord, they have stated, my lord, by way of application, they are not in a position to complete the selection process.
No.
Yes.
We have
Till the decision of the Honorable Supreme Court, my lord.
My lord have already directed.
Considering that, my lord,
Proceed, my lord, in
honorable-
another matter, my lord have directed to proceed with the.
With the old ones.
Yes, my lord.
Malad, may I,
That
may,
is the matter.
Malad, may I
That is
just,
the matter.
Malad, may I just indicate
Same
the
recruitment
crux of it?
2010.
Fundamentally, 3,233 persons have been called in the personality test. Subject matter would ultimately be out of 3,233, 277 are belonging from out of 73,000 and 2,956 belonging from the 26,000. They want the further competition of personality test should be only with this
Restricted to-
2,956.
Yes.
Now, so they want 277, they should not be allowed to participate in the personality test. So today's situation is only 3,233 are there and we are not going to, my lord, go ahead with it. So I don't
And-
think there would be any apprehensions or
and my
fear
lord,
on the part of my
and my lord,
lord.
we have also, my lord, filed an application at RTI, my lord, seeking our answer sheet as well as the marks, my lord. My lord, they have given a reply, only the marks has been given, my lord. They do not have the answer sheet.
My lord, I don't
And
think this-
against
but
that,
this
my
is
lord,
not
we
a-
have, it is our allegation in the
not a
repetition, my lord.
shortcut kind of matter. My lord, that is my understanding after the conference. I believe, my lord, it would require some time. Now, so far as the interim part and apprehensions, Lordship may record it. There is no apprehension at all as far as the petitioners are concerned. They are waiting
The
since.
whole thing is, in this matter,
Item number 16, my lord.
25th of November, an order was passed directing the Madrasa Commission to proceed to conclude the selection.
But they have taken
If
out a
you
modification application.
Lordship, I am for the petitioners in item number 70.
1 minute. We have not gone to that stage.
My lord, they have taken out an application for modification of this order.
May I?
All right.
And my lord, the honorable coordinate bench also, my lord, extended the stay, my lord, till end of April, my lord.
My lord, may I just
If
say,
there is a stay, then how can they proceed to conclude? Then these two orders of two coordinate benches are contrary to each other. Where will the authority go? देखिए एक minute.
এটা কি পার্থ সারথি?
Yes, yes, yes.
Lordship,
But
so far my petition.
there's a direction also for filing affidavit in that matter also.
Appointed. We have participated as per.
My lord, I am aware of that order. I am aware of that.
But page 2, my lord, paragraph 5, my lord.
There is a multi-dimensions in this matter. One is Honorable Supreme Court has, even today some matters are there before the Honorable Supreme Court. There, whatever recruitment has happened during the period, this act was declared ultra vires and it was ultimately set aside by the Honorable Supreme Court. So there is a long period. Now, during that period, appointments have been done by the respective managing
Madrasas.
committee. Now, the Supreme Court has protected by which we are restrained to dislodge them. Now, the number of vacancies, if they are dislodged, then the number of vacancies would be different.
Will increase.
Yes, that's the reason, my lord, I said that they don't have any fear of that anybody would be dislodged, because in any case, if those persons, we are not able to identify exactly as on today, who are the persons in all those. Total number of vacancies, 297. Now, out of 297, there is a chunk which is coming up from this period of all recruitment. We cannot dislodge them. This is one aspect of the matter. Other aspect of the matter is that the examination happened out of 3 sessions. Now, once this scrutiny was done, what I found is that based on a session 2 answer key, the entire scrutiny was done, on which basis the result was around 26,000. Now, after this Madrasa Commission Act that was declared to be ultra vires, suddenly this commission became, it was in hibernations, no functioning. Once it was restored after the Honorable Supreme Court, they found this anomaly. Effect of the anomaly was, in the preliminary examinations, some, even their records are there. I asked specific this. In the preliminary examinations, some genuine candidates should have crossed the limit of preliminary examinations. Should have. Because of our mistake in the preliminary examinations, they could not cross that barrier.
What is the mistake?
The mistake was the examination happened in 3 sessions, morning, then afternoon and evening, 1 hour, 1 hour. All questions, it's a 30 what is called as MCQ questions. All questions are same, but there are different permutation combinations, like A, B, C, D.
Yes.
Now, there was one answer key for the second session. What they did, they applied that answer key for all the sessions. As a result,
and who conducted the examination? Was it outsourced?
Well, some technical part was, of course, outsourced. That was some. Now, what happened? The ultimate result is today is this, that out of that 26,000, I get the exact number.
I don't need the number now.
Yes. Well, out of that 26,000, we can conclude the recruitment, we can fill up the post, that can be done. But on the other hand, and in fact, I have seen the other orders, the Honorable Division Bench orders also. But what I have realized after seeing, not on the surface, little depth of it, I realized there are some very fundamental facts from A to Z level were not even brought before the any of the honorable courts. So I would be seeking before your lordship that this is probably not a kind of 1 minute, 2 minute kind of matter. Some time would be required. I would be making an endeavor before your lordships to show that if the recruitment is to be confined to only this 26,000, it doesn't matter to us.
It matters.
It can be done, but then
Lordship, we have accrued our right.
There are different sets of candidates over here. One who appeared in the 2011 examination, one who appeared later on.
No, Lordship, the
one
screening
in
test
the
was
meantime.
Screening
One in
test
the
was
meantime. So sets are different.
I can only say this, my lord. Last night, for me to understand the basic part, I think the conference ended at 11:30. I think more than that. Then I just said to the chairman and the secretary that let the thing seep into my system. And I felt there has been a lot of things could have been done better. Better in a sense that a lot of information were required to be apprised before your lordships. But I can assure your lordships, at least on this part, that as far as the neutrality of these commissions, as far as free from any aspect of corruptions, my lord, as a counsel and officer of the court, I shall be assuring your lordships.
What is your apprehension?
My apprehension is that now, by the virtue of
You
the
fall under which set?
73,000.
That 73,000 set.
Right.
We participated in the counselling as per the notice dated 5th of October 2024.
He is out
and
of
suddenly
277.
that was stayed. Their notice that was stayed by the subsequent notice.
He is basically
And
now out of 277.
Now we have accrued our rights. We have participated in the common test which was conducted initially. That was the screening test. And since we have qualified in the screening test, but we were not called for any further. Now suddenly we got the invitations that you have to come for the counselling. We participated in the counselling and now we have our names are appearing in the panel. So lordship, we apprehend that if this 26,000 is proceeded with, now our chances will be completely destroyed.
Now, this is now not
Now they have to
matter
protect my
26,000.
case
Now, thing is, there are other candidates prior to you where rights have been accrued. You are the next batch.
No, we are the same batch.
No,
That is the problem.
Probably not. But may I say this? May I say
Maybe the same batch. Some have been called for the council,
Madam, may I
the
say
others
this?
have not.
Probably it would be.
Take the examination.
They did not take
They're
the
not given a
examination.
chance.
They were not given a chance.
But
I have
the
a-
Constitution bench also restricted the restriction with regard to 24,000.
May I say
Read
this?
only
May
one
I-
paragraph. Probably this can't be done.
I have read
Paragraph
10
17 of the
times.
judgment of the division bench.
This is a matter.
We would
I
have
think I would be doing a very injustice to myself if I try to
extension was sought
make
for
any submissions within a very short time.
before the division bench.
It was
The
not
division
completed,
bench
however.
admitted.
I know, I have read that. I am aware of that. I won't be shying away from any of the parts of it. So I will put all my cards before your lordships, and I would go in the way which would be most suitable for my lord. But
Yes, what do you propose an opposition?
but I am only proposing. Most likely, I would be preparing a proper written note or a list of dates, because it contains so many facts and jumbled up. So for my consumptions, now, as far as the formal part of it, since there was an order, lordship may grant us 2 weeks time. We'll use an affidavit in oppositions, but ultimately, my lord, I will come up with a note. And there are several matters, my lord. If one matter is chosen,
No, but then I have got, this is an assigned matter, I see.
my lord, this is assigned.
Why is it assigned? You go before the regular bench.
Because the
No,
Honorable Justice
already
Shobhat
assigned
Bhattacharya once appeared.
was pleased to
Once
release
appeared,
the
therefore
matter
he released.
on his personal ground.
So all matters will be released or what? I do not know.
I would be praying.
Some of the matter have been assigned before Madrasa Shen, and some
Yes,
of the,
why different benches? Let it go before one bench. Otherwise, there will be conflicting decisions and all these problem will happen.
My lord, in that case, can item 15,
Item 15.
can it be for our, my lord, convenience purpose, can item 50 be to be understood to be the lead matter, so that we can read everything on that basis?
But then whether I...
We are not the part. We are
Yes.
No, I understand.
We made an application for addition of
So far as my learned friend is concerned, what I feel is his matter has to be taken up before 15. Why? Because if he wins, then there would be complete ballot dimension different. But if 15 is hard and an order is passed in favor of 15, then my lord, all vacancies would be filled up. There would be no, the 17 would be infructuous.
There are two types of matters.
What can be done?
Now, what can be done is this, my lord.
Commission has filed a
Lordship
modification
may-
application in item 16. But in item
But
16,
this model, kindly do not look at any of the,
Right.
because I know that. I know that, but
petition,
no shortcut will solve this
It's
problem.
possible.
I don't think no shortcut will solve this issue. Lordship may take item 15 along with item 17, may be taken up.
All are taken up together. It's with, let us
I
see what
made an
can be done.
application for addition of party in item 15.
Only in, I
Alright.
want to indicate this, my lord, if Lordship enters into the depth of item 15 and thereafter decides, then there would be no reason to decide item
You
16.
try to merge 15 and 17 together because a holistic approach has to be taken.
Yes.
Otherwise, it cannot. You
Exactly,
cannot
that I-
segregate 15 and 17 and then take up.
My lord, a
Have you
similar
followed?
writ petition was
because
filed
if
before the circuit bench, my lord, while taking up the writ petition, my lord, the justice Justice Mukherjee was pleased to direct my lord to appear it along with these matters. My lord, an order was passed. My lord, may I hand over the
See, but then how can the without the Chief Justice assignment, how can this be done? Let me see once what is mentioned. देखिए एकटू.
It should be heard along with the Chief Justice.
Lord, in page number 4, my lord, of the order. Lord, the writ petition mentioned there is appearing as item 16.
Check with other writ petition pending in respect of. You relying upon this, you can seek assignment. Otherwise, a coordinate bench cannot direct matters to be taken by another coordinate bench. And this is not the regular bench either. These are assigned matters. You, 5th of November, seek assignment. In case it is assigned, all right. If it is assigned to some other bench,
My lord,
other bench will
only on one last thing. What I feel is, of course, it has to be looked into holistically for all the matters. But most likely, if item 70, if my learned friend loses,
yes,
then item 15
will
be
get a
automatic.
chance.
Not chance. It would be whatever.
Automatic.
Because what they have prayed is, it seems to me reasonable. No doubt about. There is a reasonability of it. It's not that they have sought for unreasonable thing. And there are, I have found 2 division benches order, one
Still
single
go through
benches
it.
order.
Maybe one conference is not enough. It will take more. So you go through it, all the papers.
Yes.
And then merge it, bring it to one, so that one order
all
can
I
be
want to say
passed.
is this, that
commission can use a single affidavit taking all the points so that we can circulate amongst ourselves.
that I
Yes,
In
yes.
respect of all the matters.
No, but that.
Please come.
হ্যাঁ ঠিক আছে এর মধ্যে সাবমিট করে নাও তারপর
15, 16, 17 তিনটে মামলা একসাথে হচ্ছে।
একটা দেখুন
Learned Senior Counsel representing the West Bengal Madrasa Service Commission. seeks time to file affidavit in opposition. Seeks time to file a comprehensive affidavit in opposition in respect of all the aforesaid 3 writ petitions. Stop. For the sake of convenience, the prayer made for filing a comprehensive affidavit is allowed. Stop. Let affidavit in opposition by the Madrasa Service Commission be prepared and circulated by.
My lord, initially I said 2 weeks.
Yes.
But I am told that the Honorable Supreme Court in that other bunch of matters for which we cannot dislodge them, there they have got 4 weeks. So can I get about 3 weeks?
21st of February. Reply, if any, within fortnight I give you. Yes. Go through it. Liberty to mention the matter for hearing. Reply, if any, within a fortnight.
So far, the interim orders are concerned, which will.
In which matter the interim order is there?
Well, I don't think, my lord.
The interim orders may continue.
No.
Well, there, may I say this?
Since the Honorable Coordinating Bench has
Well, I
already
don't
granted an
think there
interim order
is
till
That is the coordinate bench's order. The court is not concerned with that. Here, is there any interim order?
But there is absolutely, but I'm not, just because I'm appealing for the commission, for that I'm not saying.
No apprehension
There
now.
is no reason
So you kindly
for your
stop
lordship's time to be wasted for an interim order this matter. I don't feel so. Now, subject to what my learned friend says so.
They will not take steps. You mention. In case they take steps, you mention. This is an assigned matter. So anytime you can come and mention it because you do not have any other forum.
We are not going to give, we are not going to issue any appointment letter to anybody.
Do one thing. It's better you take down any steps taken by the commission during the pendency of the writ petition shall abide by the result of the same.
Deeply obliged.
So it is going
Yes,
to
fair enough.
one size fits all.
Yes, true. And that for all also includes for all purposes.
Certainly.
Now that certainly has entire answer. Deeply obliged.
No matter whether it's 3:30 or 4:30, this bench is there.
Yes.
Still 4:20.
Deeply obliged.
Grateful, my lord.